Hi, fellow seekers. I hope everyone is doing well. I am trying to keep the trial from here on out, the Darrell Brooks trial, of course, as much in order as possible. I have recorded a lot of things that are out of order, but as I've stated before, I do have a Darrell Brooks trial playlist, and that I'm trying to get these things in order so that if you ever need a fix, a dumb Darrell fix, you can easily find these. And I might change the titles of some of them in order for you to find them more easily. It will be a work in process, but better to start somewhere than nowhere, right? So the last video was when he was questioning Trevor Nyled, however you pronounce that, the forensic DNA guy, and I just thought Darrell made an absolute fool of himself, thinking that he could ask him all of these questions and, get his gotcha moment. And of course, he failed miserably. But then that's part of the entertainment for us, right? Where we get to roast him and his total idiocy. So I'm trying to pretty much pick up where I left off. And how things followed, I believe, was that the prosecution had Detective Casey come up again and testify for the last time. And that's, of course, when he got to show the god-awful rap video of Darrell, because Darrell kept, pushing Detective Casey. He basically opened the door, and so that's when they got to show the rap videos. But I have those in two parts. After the one that I had posted on the playlist, I had said it was Darrell Brooks throws a fit about things being unfair, thinks he knows more than DNA analysts, something like that. And that was the complete testimony, the direct and cross-exam of Chris Johnson and Trevor Nyled, which I just did more recently, separately, and more of just Darrell's cross-exam. But the complete videos are combined in one, can be found there. And so the one there will be two after that. You'll see it'll say something about Detective Casey, and there's a part one, a part two. That's kind of how it follows in order. And then the next one, I did a little bit of about half an hour of Darrell just complaining because it's his turn. And of course, if you all have watched this, he was the prosecution was very generously helping him with his subpoenas and calling the witnesses. Of course, he had a problem because he didn't think he should have to tell them what order they came in, because he didn't tell them, because the prosecution didn't tell Darrell what order their witnesses came, which was stupid, because they have to know because they're helping Darrell. They don't have to tell Darrell, but he just thinks that he is really very much on equal grounds. What I would say to him is, get an attorney. All of these things you're complaining about wouldn't be an issue if you had an attorney. You've already been advised of that. We've already looked at it. So that's just, to me, that's just a non-issue. But so there's that one. And so all that thing about him not being able to find a paper kind of tags on to this next one. As you can see him, he looks very pissed, as he is, because they're trying to get him to call the next witness, and pretty soon he's going to pitch a fit because he's going to have to call Erika, and he's already caused a lot of things where the jury came in and left, and I am pretty certain that could be on that one video, the most recent video I put on the playlist list. But like I said, I'm going to try to keep it all together as much as I can, but right now, I think Darrell is supposed to call a witness. I think he was like an eyewitness, and then it will be Detective Guth, which I think a few times he called him Detective Goof, and then of course the final questioning of poor Erika Patterson. So let's get on with this fool and see what all fun we can poke at him.
Mr. Brooks, just to make sure, don't block any of the microphones with anything. Both of those microphones should be on. You want to make sure that...
And move your dang Bible that we know that you're not using. Sorry, I'm going to have to move this up a little bit.
Go ahead, call your next witness.
Yeah, the defense calls Douglas J. Kolar.
All right.
I wish he kept his mask on.
Good morning, sir. If you would please make your way to the witness stand, which is up toward me, up one riser, and to my right. When you get there, please remain standing. Raise your right hand. My clerk, Teresa, who's on my left, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you, sir. Have a seat. First thing I will ask you to do is to state your first and last names for the record, and then spell each.
Douglas Kolar, Douglaskolar.
Thank you. Go ahead, your witness.
Good morning, Mr. Is it Kolar?
Kolar.
Kolar. Good morning, Mr. Kolar. I want to direct your attention to November 21st of 2021. Do you recall that evening pretty well?
Fairly well, yes.
Well, let me back up for a minute. First of all, what do you do for a living?
I'm an IT director for a law firm.
Been doing that for a long time?
I've been in IT for over 20 years.
Yeah, that is a long time. Direct your attention back to the night of evening of November 21st, 2021. What did you do that day?
Well, that day, I was preparing my daughter to march in the parade with her dance troupe. Watched football earlier in the day and got her dressed, and we had to change our plans last minute because my son was not feeling well. So it was just my daughter and I that went to the parade.
And do you recall what time you arrived at the parade?
It was at least an hour before the start time of the parade.
And do you recall where you were positioned at in the parade?
I moved with the dance troupe, so I
kind of going with the flow.
Correct.
And at some point you observed something happening. Would that be fair to say?
Yes.
Do you recall what that was?
Well, after my daughter had finished and I was walking back to our vehicle to go home, I noticed as we were approaching White Rock, which is what we were parked off of, I noticed a vehicle coming through where the parade participants were going. It was a red vehicle. It was honking its horn. It passed a few parade entries on the right-hand side, and then it between two of the groups, it veered to the left and went around the next group on the left-hand side, at which point a police officer attempted to approach the vehicle. That police officer had reached for the door handle, and at the time of that approach, the vehicle started to speed off.
I just want to back up just a little bit. You stated that you heard the vehicle honking its horn.
While it was on White Rock Avenue, it was honking its horn.
In your opinion, did the vehicle appear to try to avoid hitting people?
At that point, yes.
It was at the beginning of the parade.
And you made reference to it coming in, the vehicle coming in contact with an officer. Did you see where the vehicle went after that interaction with the officer?
There was no contact between the officer and the vehicle. The vehicle attempted to make contact. The officer attempted to make contact. But after that attempt, the vehicle sped southward. You know, I know those streets don't run straight north-south on Main Street.
Did you notice the vehicle strike anyone at that time?
I did not.
And what did you do after you saw the vehicle? Once it was out of your view.
Once it was out of my view, I grabbed my daughter and walked as fast as I could to my car.
And to the best of your recollection, how would you describe the vehicle as far as make and model? To the best of your recollection.
To the best of my recollection today, I only remember a red SUV.
At some point, did you report to law enforcement officers what you had observed that evening?
On the Tuesday morning following the parade, I sent an initial statement to the police.
Would that have been the Waukesha Police Department?
Yes, it was to the Waukesha Police Department.
Did you said you sent a statement. Did you initially speak with anyone verbally?
Initially, no, I did not.
At some point, did you speak with someone verbally?
Yes.
And was that sometime after the Tuesday statement that you initially gave?
Yes, approximately 2 weeks after I made my statement, I was contacted by someone with the Waukesha Police.
Do you recall if the vehicle had any tinted windows?
I believe the rear windows were tinted like most SUVs are.
Any day.
And after you had verbally speaking with law enforcement, did you do any follow-up on the reports after that?
Yes. The officer that I spoke to had advised me to add to my statement the items that we had talked about.
The law enforcement officer asked you to add certain things to your report?
He had asked me some questions, and the questions that we talked about on the phone, he asked me to add to what I had initially submitted.
And after that conversation, did you have any further conversations after that point?
I had no further conversation after that point.
Had you yourself been contacted by any further law enforcement after that point?
No.
So it'd be fair to say that you were subpoenaed to testify at some point. That'd be fair to say?
Yes.
Do you recall when you received that subpoena?
I received my subpoena last Tuesday.
The 18th?
Whatever day last Tuesday was.
Do you recall whom you received that subpoena from?
The Waukesha County Sheriff. Or
Do you
one
recall?
of the sheriffs.
I'm sorry.
Or one of the sheriffs.
Oh. And did you do any follow-up information once you received the subpoena? Like, for example, sorry. For example, calling the district attorney's office?
I did not call the district attorney's office. I did reach out to the clerk's office to see if there was any further information.
Were you or your daughter injured in any way during this incident?
No, we were not.
Any day. Excuse me. That's very many.
No further questions at this time.
You could have had an opportunity to ask a lot more, I bet.
Yes, Your Honor, thank you.
Ooh, let's see what Upper
Good
has.
morning, Mr. Kolar.
Good morning.
Thank you for being here. To be clear, sir, the subpoena you received was issued on behalf of the defendant, Darrell Brooks, correct?
I don't know. That information was not filled out on the subpoena.
Oh, yeah, that would be correct.
You did provide a typed statement to the Waukesha Police Department, correct?
Objection, leading.
And
Overruled. Oh, if there's an objection, let me rule on it first before you answer. Overruled, go ahead. And his answer, I believe he answered it, but if not, did you answer it?
I'll ask again.
Thank you.
You did provide a written statement to the police department, correct, sir?
Objection, leading.
Overruled, it's cross 90611 sub 2.
Yes, I provided a written statement.
And in that statement, you described the SUV as driving erratically down White Rock Avenue, correct?
Objection.
Uh-oh.
Didn't testify to that.
Oh,
That was asked and answered.
No, not really.
overruled the witness may answer, and it's sub 3, not sub 2.
Looks so.
Go ahead.
He looks.
Yes, just the event
Hang on a
of
minute. I'm sorry.
driving past some participants on the right and then veering to pass the next group on the left.
Okay. You said at that point, when the vehicle was on White Rock, it was honking its horn, correct?
He's waiting for him to object.
Correct.
There was no objection. You can answer.
Poor thing.
And you saw an officer run up and try and open the door to the vehicle, correct?
I don't know that he was trying to open the door, just trying to, I don't know what he was trying to do. He ran and his arm had gone towards the door handle.
Okay. And that was at the intersection of White Rock and Main Street, correct, sir?
Yes.
And you got a look at the driver of the car, correct, sir?
Objection speculative.
Overruled.
No, it's not
Witness may answer.
speculative.
Yes, I did.
And you described the driver in your written statement as a black male with dark dreadlocks and visible tattoos. Is that correct, sir?
Ooh,
Objection leading.
Overruled.
pretty good
Witness may answer.
description.
Yes.
Is that consistent with your memory, sir?
Objection speculative.
Overruled.
That is consistent with my memory today.
Once the vehicle went past the officer, you indicated that you saw it accelerate or speed off. Is that correct, sir?
Objection leading.
Overruled. 906.11 sub 3.
Yes, at that point, it sped away.
Thank you, sir. I don't have any other questions.
Any redirect?
Briefly.
Go ahead.
Okay, let's see if you stick to your briefly.
Referring to the written statement that was just testified to the best of your recollection, do you recall stating that the SUV was a older model red Chevy Blazer?
I do recall putting that down at the time, but that was at that edition that I added 2 weeks later.
So at that time, during the evening of the incident, to the best of your knowledge, that would have been your opinion of the vehicle that you saw?
At the time of that, the day of the parade, I just remembered the red SUV.
To the best of your recollection, what assumption will lead you to describe the vehicle as a Chevy Blazer?
I believe in my assumption, it was just to say it was a older, boxy style SUV, and in my mind, that relates closely to a Chevy Blazer.
No further questions.
All right, thank you. You may step down.
You didn't get very far with that at all.
And you also are excused. Thank you for being here.
I don't even know the point for him calling that
You may call your
person.
next witness.
One second.
Get your stuff together.
If I may have just a quick second.
Oh, why not? You've taken up more than a second. Repeatedly.
The defense would call Stephen Guth.
I believe one of my assistants went to retrieve Detective Guth, Your Honor.
Thank you. Right, good morning, Detective Guth, if you would, as you are, come to the witness stand, remain standing, raise your right hand, and my clerk Teresa will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Please have a seat. Please state your first and last name for the record, or names, I should say.
Stephen Guth, Stevenguth.
Go ahead, sir. You're with.
How long have you been in law enforcement?
Over 20 years.
And how long have you been a detective?
Just over 7 years.
Directing your attention to the evening of November 21st of 2021. Do you recall that evening?
I do.
And were you on duty that evening?
Not initially.
For more clarification, what do you mean by not initially?
It was a regular off day for me, but I received notification to respond to the police department for the mass casualty incident in the downtown area of Waukesha.
So at that point, I'm assuming you were dispatched to that location?
I was not dispatched. I received a signal message. We use Signal. It's an app that's used that we can share information for investigations. And I received a signal message that this tragedy just happened.
Attacked.
And so what did you do from that point?
I immediately dropped my wife and kids off and responded to the parade.
And when you got to the parade, what did you do at that point?
I went to the downtown area to assess and see what I could help with.
At some point during your investigation, did you make contact with the woman by the name of Erika Patterson?
Yes.
And what was the nature of that that part of your investigation?
I wanted to speak with Erika Patterson because by that point, when I made contact with our command center, they had learned the name of Darrell Brooks and had learned that Erika Patterson was the estranged girlfriend of the suspect of this investigation.
You made reference to estranged girlfriend. What do you mean?
Just what he said.
I don't know if I should answer that.
I think the question was pertaining to the word estranged, but we'll move on.
The jury will disregard that last question that has been withdrawn.
Mm-hmm.
And the statement made by Detective Guth following that.
I'm assuming at some point you took a statement from Ms. Patterson.
I did.
Do you recall if it was recorded, written, you writing it? What was the nature of how the report was taken?
Well, her words were spoken and they were recorded, and then I prepared a report.
Did you prepare the report that same evening?
No.
When did you prepare the report?
Sometime after the 22nd of November.
Why not the same evening?
Because after I spoke with her, I wanted to go back and speak with her again.
You know what? I wish he had his mask back on. Because look at that. Those, whatever he's doing with the tongue inside of his mouth and all his hideous facial expressions just make me want to hurl. And he just looks so cocky. And he's gonna just like put his foot in his mouth repeatedly, and he doesn't even know he's doing it. Oh my gosh. I just, after all this time that I've spent studying him, I still can't become immune to how sickening he is to look at and to listen to all of that. Ugh.
Did Did you obtain any statements from any other people that may have been involved with Miss Patterson?
I did not.
Do you know, to your recollection, if any other officers have taken statements from parties that may have been involved with Miss Patterson?
Well, the night of November 21st, 2021, I did have a partner with me, another detective.
Do you recall him talking to any other parties that may have been involved with Miss Patterson?
Well, the detective that was with me was a female, Detective Barron.
The question was, do you know if your partner had any interactions with parties that may have been involved with Miss Patterson?
I don't believe so.
Hold on,
but
are
I
you
can't-
specifically referring to a date certain or just in general?
I think he was clear.
I
The
need
date
it
would
clear
be-
for the record,
The
though.
date would
That's another thing. And I know I've commented on this multiple times, but every time he says, I think it was very clear. It's about as clear as mud, whatever he says or asks. And then yet he doesn't understand anything. Ugh.
would be
On the
November
21st?
21st
Okay,
of 2021.
thank you with that clarification.
No, I don't believe so.
Can't stand his tone. Ugh.
Did you learn at any point that there may have been other parties involved with Miss Patterson?
In which incident?
I'm referring again to November 21st of 2021.
Looks so
Yes.
condescending.
Do you recall who those parties were?
Corey Runkle and Nicholas Kirby.
Did you yourself speak with either of those parties, Nicholas Kirby or Corey Runkle?
No, I did not.
Do you recall if your partner spoke with any of those parties?
Which partner?
I'm guessing the female partner that you made reference to.
No, she did not.
And in that recorded interview with Miss Patterson, what did you learn about the evening of November 21st, 2021?
Which recording?
Are there multiple recordings?
Yes.
What did you learn about the evening of November 21st, 2021 from both recordings with Ms. Patterson?
Your Honor, I'm going to object at this point as this testimony covers ground that was very clearly covered during the state's case in chief.
I'll give Mr. Brooks some leeway. You are asking for hearsay, though, you understand that?
I asked him, what did he learn?
You're asking for hearsay.
Go ahead, you may answer.
I learned several things. Initially, I think was what you were getting at. Ms. Brooks wanted to report that she was injured by Darrell Brooks on November 20th, which would have been Saturday. She stated that she met with
That was the date they were
Mr.
supposed
Brooks
to
at
talk
Green
about.
Park, and they were arguing over the fact that she did not give him money, and he injured her by slapping her in the mouth and punching her in the eye. The next day, I went back and talked to her again, and she clarified that that actually did not happen on the 20th. It happened on the 21st, and that she got in a motor vehicle with him over the same argument. He was mad that she did not provide him with money. He proceeded to try to take her phone because he thought she was talking to other guys, slapped her in the mouth, punched her in the eye. She jumped out of the motor vehicle because she feared for her safety and made her way back towards Frame Park. While walking back towards Frame Park, she was calling her friends, Corey Runkle and Nicholas Kirby, to come help her. When she arrived back near Frame Park in front of White Rock School, there was a confrontation in front of White Rock School with Mr. Brooks, Erika Patterson, Corey Runkle, and Nicholas Kirby, where there was some kind of shoving match, and that's when Mr. Brooks got back into the motor vehicle and took off down White Rock towards Main Street.
You made reference to being told about an incident from Saturday, November 20th. And then stating that in the second interview, Ms. Patterson stated that didn't happen. Is that correct?
She didn't state that it didn't happen. She just stated that she didn't drive around with him on Saturday, November 20th. But she also met with him and was slapped in the mouth that day too.
There you go, Darrell.
If it pleases the court, I have a document here I would like to show the witness.
Right, if the bailiff could go to the state first to look at it. You may use the document camera if that's hooked up. Otherwise, the bailiff can take it to the witness.
Before we go through that process, I'm going to object. Maybe
Let
we
me
should
see the
cut
document.
Yeah.
Look at this. I want to slap the smug off of that face.
All right, you give that back to Mr. Brooks, given the content of that document. I'll sustain the objection, or what that document is, I should say.
Sustain on what grounds?
It's not relevant, to this witness's testimony.
How is it not relevant?
They're doing this to protect you because of the other crap.
It's not relevant.
You made reference to November 20th.
Oh my gosh.
That's what this document is talking about.
It's not relevant to the charges at issue. We can take it up later, and if need be, I'll let you recall the witness, but I'm directing you to move on to a new topic.
Your Honor, I'm going to respectfully object to that and ask for finding the fact.
The objection's noted, it's sustained. Well, their objection's sustained, yours is overruled. Please continue.
Is that noted for the record? I would like a written finding.
Just shut up and move on.
Request is denied. Keep going, please.
Denied on what grounds, on what lawful law?
Keep going, sir. It's not relevant.
This is all in front of the jury.
Judicial determination that you don't have to answer that question as a public servant.
Sir, I've ruled on the objection. It's on the record. Please keep going.
Once again, information that needs to be known is being hidden.
Oh boy. Well, let's get it all out. Let's
Not
open the door.
relevant, sir. Please continue.
It's very relevant.
Wow.
You just opened the door on that by saying November 20th.
Uh-huh. And you remember what they said about that?
Objection. Move to strike all of the comments made by Mr. Brooks in the last 20 seconds or so, especially with regard to any implication that he hasn't had all of the discovery material.
Objection, I never made any mention of not having any discovery material.
Oh, shut up.
That never
The
was
jury will
stated.
just disregard, as I've told the jury repeatedly, comments made or statements made by the parties, whether they be lawyers or the parties themselves, are not evidence, and you're to disregard them and not consider them in any way. And if the statement suggested facts that are not in evidence, you should not consider that in any way either. All right, go ahead. Your next question, please.
So is it fair to say that in your report you referenced 2 incident reports?
Objection. This
Grounds.
witness wrote.
I'm gonna overrule
Fine.
the objection and let the witness answer it. I think it might just be semantics at this point, but
Well, let's just hope it's semantics, because sometimes it seems the judge doesn't always get it right. Let's see what happens though.
go ahead and ask your
You
question.
mean semantics.
Oh God, please. We don't have time to give
I
you
think
the
were referring
dictionary.
to that he had 2.
That's what his report says. He makes reference to two reports. Two
Yeah,
incidents.
all
2
right.
incidents,
Yes.
not 2 incident reports. Reports would be separate documents. That's what I'm talking about. With that understanding, that you're referring to, I think you're referring to incidents with Ms. Patterson, correct?
Yes.
Go ahead, ask your question. I think that clarifies, so that the witness can answer.
In your, let me back up. You wrote your own report. Would that be fair to say?
Yes.
And in your report, you referred to 2 incidents. Would that be fair to say?
Just to clarify, which report are you speaking about? I wrote several reports.
Do you have all your
one
materials, Darrell?
Written November 22nd of 2021.
I do reference 2 reports and 1 CAD call.
What was the last part? Cat call?
A CAD call, yes.
What do you mean cab call?
Oh God, you have to
Cat.
explain everything to him.
CAD.
Cat
call.
What do you mean cat call? What?
That's a call for service that does not generate a police report.
And what was that cat call?
That was a call for service near Frame Park for a fight involving potentially a domestic related incident.
Do you recall any other details about that CAD call?
There wasn't much in it because the officer had to leave to go to the parade.
Do you recall mention of a knife during that CAD call?
Yes,
To the best of your recollection, do you recall anyone recovering a knife or you yourself recovering a knife?
there was no knife involved in that incident through my investigation of the report that you have.
But it is fair to say that that's how the CAD call went out, that there was potentially a knife fight.
That's how it was initially, I believe, reported or communicated through dispatch to the officers that responded.
You made reference, and I'm referring to the second interview with Ms. Patterson. You made reference in your report that in the previous interview that Ms. Patterson was not completely forthright. What exactly do you mean by not completely forthright?
She did not give me all the details of the incidents to me initially.
Do you recall why?
I don't know why she didn't.
So it'd be fair to say that Ms. Patterson had been untruthful with you in the first interview.
No, Darrell.
No, she told me she was extremely afraid of you. And that's why she didn't want to tell me everything.
Not being forthright is
Well, you
lying.
just stated that
No.
you didn't know why she was
I can't read her mind, but that's what she told me.
You're getting nowhere. Any day, any damn.
At any time during your investigation in regards to the incidents with Ms. Patterson, did you at any time see interviews that were conducted with Nicholas Kirby and Corey Runkle?
What do you mean by see them?
Had you seen any statements made by those two parties?
No.
Would it be fair to say, assuming that those two parties were present for the incident on the evening of November 21st of 2021, would it be fair to say that at some point they were interviewed by law enforcement officers, to your recollection?
Yes.
And you've never seen any of those interviews?
They weren't video recorded.
Had you seen any written statements from them or report from law enforcement?
I received a summary of what they stated verbally from another detective, yes.
So it'd be fair to say you did have knowledge of what they said transpired on November 21st of 2021.
I acknowledge what they said. I didn't see anything.
These questions are so,
And to the best of your recollection, seeing what those two parties had said, what do you recall?
Objection.
Grounds.
wouldn't that be hearsay?
Evidence. You see what they said and also calls for hearsay.
Sustained.
What did you read
Objection.
from
No,
those
no.
statements given by those two parties?
Objection. Calls for hearsay.
Grounds.
Sustained.
Grounds for the sustain.
Calls for hearsay.
I already told you. Move on. Oh, Lord. He's just really not getting anywhere. He's wasting time. I don't think he even knows what he needs to ask. Look at him looking over there at them suspiciously. He's such a child.
Do you recall what officer took those statements from Nicholas Kirby and Corey Runkle in relation to the incident on November 21st of 2021?
Yes. Yes.
And what law enforcement officer was that?
Detective Darrell.
Come on. What else you got?
after that report that you wrote on November 22nd of 2021, was that the end of your investigation into the incident of November 21st of 2021?
No.
And what was the extent of your investigation after November 22nd of 2021?
Judge, I'm gonna object. Well, on the defendant's behalf, I believe here, based on previous rulings the court has made.
Sustained.
Come on. You got a lot of flipping and flopping and flopping to do. Come up with something. You're doing a terrible job protecting yourself. Okay, let's go. Gosh, he's wasting so much time, guys. I might cut a lot of this paper flapping out.
Did you speak with Ms. Patterson again after filing your report?
Yes.
In reference to the incident from November 21st of 2021?
I don't understand your question.
Seriously.
Did you speak with Ms. Patterson after you filed your report in relation to the incident from November 21st of 2021?
No.
In relation to the alleged incident on November 20th of 2021, do you know if that alleged incident ever took place?
Objection.
Grounds.
Calls for hearsay, lack of personal knowledge.
You reported it.
Oh, for gosh sake.
It also goes to one of the ultimate issues that the jury will need to determine, so it's sustained.
You don't get it. They're doing this all on your behalf and you don't get it. Darrell, come on. You're not getting anywhere with this Detective Guth. You should know better than to question any kind of police or detectives because they're going to get you every time.
No questions, no further questions right now at this time.
All right, thank you.
All right, let's see what else. What do we got here?
No, Your Honor.
All right, thank you, sir.
Oh, they're going to let him go. All right.
May have something later for that particular witness.
All right, I'll try to raise that on an appropriate break. Call your next witness, please.
Is there only one witness left?
Yes. For that, yes, for that time. Yes. I
No
believe.
one else is here?
No, it's not 10:30 yet.
who's supposed to come at 10:30, Your Honor.
Call your next witness, please. I don't have that list right.
Oh, yeah.
So what happened?
I'm sure you remember this whole crap about the list. Of course, as most of us already know, the prosecution generously offered to help him call the witnesses on his list, but in order to call them, they have to have an idea of when they're going to tell them to come in. But Darrell does not want to tell that, because since the prosecution didn't have to tell him what was on their list and what time they came, and so he's just feeling like he's so above everyone else that he's, it was like when they tried to help him with the list, no, but then he wouldn't do this or that. It's just like he was impossible to help. And so he's going to be all bitchy about this, but let's watch it.
I don't have that list right at my fingertips, but I know there's a witness available, so please call your next witness.
Can I be provided that 10:30 list?
Number one, he should have written his own list. He didn't take down his own list. He expects everyone to do everything for him. I wouldn't even talk to him if I were her.
Does the state have that? You can pass it over. I don't have that at my fingertips.
Sure, let me jot it. I have it, but I'll write it up for Mr. Brooks to review, Your Honor.
Thank you. While we're doing that, if the jurors want to stand for a minute, go ahead, or anyone else in the courtroom.
Good gosh. You know it's Erika. I don't know why they have to make this big to-do and tiptoe on eggshells.
I accept for value in return for value this
God.
paperwork.
Thank you. If everyone would have a seat then. Please call your next witness.
And who determined this order?
Ugh. They've been all through
Mr. Brooks,
this.
I'll take up that issue outside the presence of the jury later. There's a witness available. Please call the witness.
That's not the witness that was intended to be called at this time.
I understand that, sir. Under 90611, I have the authority and the discretion on that, so please call the witness who's available.
So I'm being rushed to jail.
No.
No, sir, I'm trying to have an effective and efficient use of all of our time. So please call the witness.
Which is respected, but at the same time, being that this is my time
Right, I'm
to
going to
present my
excuse the
defense.
jury.
My
right
time,
now.
my defense.
I'll rise for the jury, please.
Now we have to send the jury out again. Gosh, I can't believe all the time that's wasted. This idiot.
All right, thank you. Be seated. Mr. Brooks, under 90611, I do have the authority and just my inherent authority over this case to require you to call the next available witness. You, in my opinion, were not entirely cooperative yesterday with the
No,
process.
he was
so
not. He was an
I
ass.
told you that 3 witnesses would come in at 8:30, 2 would come in at 10:30, 2 would come in at 1:30, 2 would come in at 3:30, and then if there were any left, I wasn't sure if there were or not, would come in at 4.
You also didn't provide me with that list.
You were advised on the record,
But
sir.
you didn't provide.
He shouldn't have been provided with a list because when they were talking all about it, he should have written it down. He doesn't write anything down. He doesn't accept any paperwork for him, and yet he expects them to read all of his stuff and for the judge to check on his idiot complaint forms. It's just, I can't believe I still get so annoyed with him.
Provided to me.
Sir, you chose not to write down. So
That's
on
right.
you,
Thank
not
you.
me.
No,
You
that's
chose.
So,
you
here's
can't.
the
That's
thing.
a rush to judge.
Erika
That is
Patterson
not-
is
no,
here,
I hate
so I'm advising you that she will be the next witness that you call if you so choose. If you choose not to call her right now, then I'm releasing her from the subpoena because we have almost 45 minutes until 10:30, just slightly under that. And there's no reason for you not to call her. She's on your list. She was on the listing as I understand it, the groupings of 3.
It were.
Tuesday
She
morning,
went over it.
Tuesday afternoon,
Did you
Wednesday
receive it?
morning, Wednesday afternoon, and so on and so forth. That's the order. I told you very specifically, I'm not going to have everyone come in at one time because that's not efficient, that's not effective, and it's not courteous to them.
He doesn't
People
care
have
about them,
families,
though. That's
people
the
have
problem.
Jobs and other responsibilities, and we're trying to be mindful of all of that as well while having the state assist you in getting these people here. So I'm advising you that if you don't call her right now, you will forfeit your right to call her.
Is that lawful law?
Sir, I believe I have the authority to do that. She's here, she's ready to go.
I'm just
She's
asking.
your
Take your
witness.
lawful
Just asking a
law
question.
and
Is that
shove it
lawful
where
law?
the sun doesn't shine.
I have the authority under 90611 and other rules and the inherent authority of this court to control the order
Ridiculous.
and mode of interrogation
Excuse
Your
me.
Honor,
of
why is
witnesses.
it always so hard to just say yes or no? Is
Yes,
it lawful
I have
law?
the authority.
You know, isn't that interesting that he says that when she can never, ever get a straight answer from him? Very interesting.
Authority,
Oops, sorry.
sir.
I'm not disputing that.
You just
I'm not
disputed
disputing.
that.
No, I asked the question, is it lawful law?
Sir, I told you what I believe my authority is. Okay,
You
if you
told me
don't want
what
to
you-
recognize it, that's
told
fine.
me
You
your
want to
authority.
object and note it, that's
Told
fine.
me your
Your
authority.
objection
I'm
is
not
noted on the
debating
record.
your authority. I'm not.
Yeah, you
So,
are.
I will address one other issue with you because you said you had an issue regarding the last witness, which is fine. We can address that quickly, and then I'm going to have the jury brought in, and that will be your opportunity to call
That's a
Ms.
misdirect.
Patterson.
That's a misdirect. What issue did I say I had with the
You
last?
said you wanted to raise
I
an
said-
issue with about Detective
What I said
Guth's
was
testimony.
I might have more questions for that witness. I didn't say it was an issue.
Oh, I didn't hear that, sir. You had your opportunity to ask the witness questions. He's been released.
Yeah, you can't go back and forth.
Your Honor,
Oh, I hate
if
when
I mumble something
you.
under my breath, somehow that's audible.
breath.
But when I talk clearly, somehow
I may
nobody
have
hears
missed
me.
it, but I heard what I interpreted was when you said I may have an.
Why does she even have to explain anything to him? She shouldn't have to explain anything to him. He's not an attorney. He's the defendant. Now we know he is the convicted person. I don't know why she spoon feeds him so much.
An issue with this witness. I didn't understand. I guess I didn't take that as you were going to reserve your right to recall him. Are you telling me you'd like to reserve your right to recall Detective Guth?
Yes.
All right, then that will be noted.
I wouldn't
and
even do
we'll keep
that.
him under the subpoena.
She's given him way too much,
Now,
in my opinion.
that should address that. I'll have the jury brought back in, and you should be prepared if you
Look
choose to call
down.
Ms.
Quit
Patterson.
looking up there.
This
There's
is your
nothing for you.
opportunity to do it.
At the same time, though, that's still a rush to judgment, Your Honor.
No.
I shouldn't be forced to call people in the order that I'm being told to when these are my witnesses.
My
My
witnesses.
You did not
Wow.
want to provide us with the order, and I respected that, Mr. Brooks.
But I said that
And
from the
so
beginning.
then I asked
Your
you
Honor,
to put
with
him
all
in
respect,
blocks.
did I not inform Your Honor and the court?
Yeah, we
that
all
I
heard
would
it,
not
but
give a specific order.
no.
I stated that numerous times.
And Mr. Brooks,
Numerous
I
times.
have authority to tell you otherwise. You
I
may
did.
not like it. You may disagree with it.
It's not
You
about
have
that.
been-
It's about the rush
You
to
have not been
judgment, Your Honor.
cooperating with this process. The
There's
state
nothing
has
to cooperate
graciously
with.
agreed to assist you given your custodial status.
Okay, and I never asked them to
frankly,
do
any
that.
attorney in this
I
situation
never asked them to do that, Your Honor.
would give us the order.
Did I not? Did I ask them to do that? I did not ask them to
Don't
do that.
engage with
They
this
volunteered.
conversation. Tell her.
They offer,
So at the
it's
end
done.
of the day,
but we expect
if
your
they didn't want to do
cooperation
it,
in that.
yeah, but that wasn't one of the stipulations when they offered.
Why can't she just stop it right now and say, okay, we've already talked about this way too much. This is done. We're moving on.
To do it, Your Honor. Let's
No, common courtesy is the stipulation.
okay,
sir.
but it
And-
wasn't
and here's the
stipulated
thing.
to, so I didn't have.
You are well advised of how this process was going to go.
No, I was not.
It is
Because
Yes, you were.
in a trial.
You can't
to call
put the people.
witnesses.
You can't
out
put the
of
people
order
in a
based on
specific
their
spot for
availability.
me, Your Honor. Come on now.
It is.
That's a rush to judgment.
There's no rush to judgment here. You
Did the
keep
state
saying
did the
that,
state
sir,
have to
but
put
that's
their
not the
witnesses?
case.
Your Honor, with all due respect, did the state have to put their witnesses in order and tell me?
It's irrelevant what the state did. in
Did
that
they have to
regard.
do that?
They didn't need your assistance to do that.
Did they have to do it?
No, they did
I
not
didn't have to be
do it.
provided with. We're going to call this witness at this time.
But
I would,
they're
you know
able
what?
At
to
this time,
contact
they
their
didn't have to do that.
witnesses.
Why can't she just say, okay, you know what? You have lost the right to question Erika if you're going to complain so much about all of this. Ugh.
So why should I have
And
to do that?
accommodate their schedules. This is not about you. It's not about the state. It's about the witnesses'
It's about what's fair.
availability.
It's about what's fair.
No, frankly, sir, it's about you trying to control what's happening in this court.
How am I controlling what's happening? I'm the one shackled to the table with
So
a
here's the
with a
situation.
shock device
It is
on my ankles.
9:52.
So how's I'm trying to control anything?
I'm
I
happy
just
to-
want this
I'm
to be
going
fair, and it hasn't been fair.
Mr. Brooks, it's fair.
No, it's not. If I have to do something that they don't have to do, how's that
Oh my-
fair?
Because you're not an attorney.
It's fair
Explain to
because
me how that's
the
fair.
process
You're not an
has
attorney.
been set up to frankly help you. get
No,
the
it's
witnesses
not helping me by
to
it's helping
court.
the state
And no,
by being able to say if we know the time and we know
You
the
did
person
not-
and
I
we know
asked
this,
you-
then we can be prepared. So we'll already be ready.
Mr. Brooks,
That was
I
the
asked
whole
you
aim of that.
yesterday, and I would have had her come in later. You didn't want to answer that question.
You did not
There was
answer
no
the question.
There was no question to answer.
Yes, there was.
That's not
I
true.
did what you asked me to do, Your Honor. You
No, you
said
didn't.
Quit
yes, you
arguing
did.
with him.
You did. You asked me
Stop
to
it.
give them my witness
Mr.
list.
Brooks,
I
yesterday,
gave them my witness list. It's not my fault.
I very
It's not my fault they
expressly-
weren't gonna be prepared.
Oh, please.
To do
Mr. Brooks,
their-
here's
You
the
are
deal. You're
ridiculous.
coming out, and I'm going to stand my ground on this.
I'm gonna
Okay,
stand my
it
ground
is-
too, but I'm
if
not
you
gonna
don't call
be
her-
disrespectful and disruptive.
If you
I'm just
don't
stating I
call
want it to be
her
fair.
When the jury comes back out, I'm releasing her from the subpoena.
You can't do that.
For
Law-
your
where's
lack
the
of
lawful law?
cooperation.
Where's the lawful law? I have the right to
You have to
witnesses,
call-
Take your lawful law
but
and
I
shove it.
also have the Sixth Amendment right.
We have a witness available for you to call. I can require
It's
you
not
to
the witness
call her
that
right
should have
now.
been called at this time, Your Honor.
It is based on the list that you provided and
That
in
didn't
the
have a
order.
time. That didn't have a time or
I'm not going
or
to
an
play
order.
this game with you,
It's
sir.
not no game. That's what you don't
It
seem
is
to
a game
understand.
you. I believe that fully.
I don't care what you believe fully.
All right.
It's not a game.
We.
I don't take
I
this
asked-
as a game. That's what
Let me
nobody.
explain this to you
That's what
once
nobody.
again.
You don't gotta explain nothing to me.
Do you want?
That's what you don't understand. You think
you
that
want
this
the
is a whole
opportunity
game
to
to me.
question?
This is not a game to me, Your
You
Honor.
sure made it a game.
Nothing about this is a joke.
I never.
That's
said
what
it
y'all
was
don't
a joke.
understand.
I think it's a little bit funny.
There's-
It is unfair. It's unfair. And it's
Oh.
disrespectful to me
Oh,
that you think
man.
I would come in here purposely and treat
Sit
this
down
like
and
a joke or a
shut
game.
up.
I never said it was a joke.
What type of statement is that?
Mr.
Your life is not on the line. Mine is.
Yeah,
And you think that I think this is funny?
I don't think it's funny whatsoever.
I think it's a little bit funny.
So
I
I
understand.
think, Your Honor, with all due respect, I think you
So
should show
we're
some
gonna take
respect.
a 5-minute break, and when we come back, the jury's coming out, and you need to call your next witness. Thank you. We are in recess.
Nah, you're not rushing me to judgment. I don't care.
So now they've gone on their break, they've come back, and she's going to call the jury back in. Hopefully Darrell will cooperate in doing his direct examination of Erika Patterson. But I actually had to stop last night, and because it was getting late to record this next part, and I'm glad I did, because it was really getting me so agitated and irritated and just like, ugh. And I don't like to be that way because I'm not that way, but he just, and now I figured out why he doesn't have his mask on, because he wants Erika to see his full face. But I detest it because I see all of his dreadful expressions and his eye rolling and whatever he's doing with his mouth, or chewing the inside of his mouth, or pursing his lips, or whatever. And all this time he had such attitude with Detective Guth and with Judge Dorow, and he's just like prancing and preening like a peacock or a rooster. Well, it's all because of Erika, because he is obsessed with Erika. Erika, it's not her fault what he did in the parade and everything, but everything is based on him becoming so emotional and angry with Erika. Just like it, he seemingly seemed to be jealous that, Nick was with Erika. Probably was afraid they had something going on, and if they did, so be it. And the thing is, he wants to possess her. He wants ownership of her. It has nothing to do with him caring about her. It's him being obsessed with being in control of her and making her life a living hell. Hell, that sounded real southern, didn't it? And that's what aggravates me. And he's using all of this to take out on Judge Dorow, the prosecution, the witnesses, all of this. And at the end of the day, 6 people are deceased. Their families are devastated, and he doesn't care about that. Just like when she was trying to talk to him about, like, he was pitching a fit about the prosecution didn't tell me what they had on their list. Well, of course not. They have their shit together. He doesn't. They helped him. Well, I didn't tell him they had to do it, but would he not have fussed if they hadn't have helped him with it? He would have complained. He would have brought all his paperwork in, along with his idiot complaint forms. And oh my God, here I am. I'm starting fresh, and I already have a headache. And it's just because he is so disgusting, vile, soulless. And again, of course, this is only my opinion. I'm not anything, not a psychiatrist, psychologist, an attorney, just somebody who's has a little bit of sense, and hopefully more compassion. Well, most of us would have more compassion than him. Okay, are we ready? Let's see how it goes. So I think they're actually getting ready to call the jury in, and he's probably, I can't even remember this part because I have not seen it in a while, but he's probably going to run his gator about something, subject matter jurisdiction, which hasn't been proven. And while he thinks maybe that he's getting to the jury, I think he really thought that. He is not. I think they're sitting there disgusted and saying, when can we lock up this animal? But I will shut up for now. At least I'll try. When I get triggered, this is what I do. Okay, let's go.
And it still has to be proven for the record.
Oh my gosh.
Decline to do so. Your objection is noted for
Is
the
the
record.
audio on?
Unfortunately.
Your objection is noted for the record.
Is the audio on?
Yes, it's on, sir. It's on.
So we're not going to address subject matter jurisdiction.
No, because it's stupid, baseless, and it's...
For the record, I have addressed it.
No, you have
And
proven it
here's
for
it
the
written.
record.
She has. You ripped it
Your
up.
objection is noted for the record.
Proven subject matter jurisdiction.
You ripped up the paper.
Proven it.
He's shuffling his damn papers
Prosecution.
around.
Oh, okay.
We don't need to prove anything but to get you up under that prison.
So that's your judicial determination that you don't have to answer that, Your Honor, being a public servant?
I was talking to my clerk. I didn't hear what you asked. The jury's coming in.
You heard what I asked.
I actually did not.
Come on, Your Honor. Come on.
Shut up. Just shut
Come
up.
on now.
Get preen your little peacock feathers. Get all ready for Erika so you can abuse her.
You know you have to prove subject matter jurisdiction.
She doesn't have to
You know
do crap. You just need to shut up and get on with it.
that. You have to honor your oath of office. You know that.
Honor your oath. You oaf. Now watch how he does, Erika. Probably very poorly. God bless the bailiff or
Thank you, everyone. Please be seated.
behind him for holding his composure.
The defense may call its next witness, please.
Give me 1 second. I'm trying to make sure I got the paperwork since I'm being rushed to judgment.
Wow. Yeah, the jury's impressed by that, let me tell you. He's going to purposely take his time.
That's not right. Oh, there you go.
He absolutely thrives on being in control of the whole courtroom. All eyes are on him. He's controlling everything. Oh man, I just want to hit him over the head with one of his water bottles. Sit down. Your smug ass face. Okay, I need to shut up. I need to calm down. I gotta watch out not to have too bad of a potty mouth, guys. When I get triggered, there's no telling what I'll say.
Defense calls Erika Patterson.
Thank you. We'll have her brought in.
So I'm being rushed to judgment.
Yeah, the jury's impressed by that. Mm-hmm.
Good morning, Ms. Patterson. If you would please make your way to the witness stand, which is on my right. You may recall it's upper riser. When you get there, please remain standing.
I'm looking at her.
Raise your right
Sickening.
hand, and my Teresa, who's across from you and on my left, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you. Please be seated. First thing I will ask you to do is to state your first and last names for the record.
Erika Patterson.
Thank you. Go ahead, your witness.
Oh my gosh, what is he doing?
When spelling the name.
I believe it's on the record from previously, but go ahead. You can spell your first
He had her
and last
spell her name again.
I'm sorry about that. 1 second. I'm trying to find this paperwork.
I don't believe that he's sorry.
When you're ready.
Oh gosh, don't say that. You already know what you're going to ask her. You don't need any stupid notes. Look at Zach. I mean, Zach has that face where he's trying to compose himself, but I think he would love to just punch Darrell in the face. Probably all of them.
I'm just gonna start the questioning. I'm not seeming to find paperwork that I just had on the table for some reason.
Yeah, Audrey, yeah. Somebody took your precious paperwork. Don't flatter yourself. Just get on with it. Yep, stand up to try to look tougher.
Good morning.
So what do you do for a living?
I have my CNA certificate.
I'm gonna direct your attention to the evening of November 21st, 2021. Do you recall what you were doing that evening?
I was hanging out with my friend Corey at Frame Park. I had spoken to you, Mr. Darrell Brooks. You came out there at Frame Park and met me after Miss Corey separated from me with her friend. Me and you got into an argument.
Whoa. Pursuant to the question?
I am answering your question.
I was referring to the judge.
Oh, he's going to be
I
such
think I
a...
kind of got a little ahead of...
Oh. Mr. Brooks, I'll let you interrupt the answer and you can ask a follow-up.
Oh my God, I can't.
I apologize. I was instructing the clerk to turn up the volume. So go ahead, ask your question.
Same question?
Sure.
Gosh.
What were you doing the evening of November 21st, 2021 before linking up with the alleged defendant?
No, the defendant.
My roommate at the time at Frame Park.
And what were you and your roommate doing?
I'll object. We covered this ground during her testimony previously.
Sure did.
Objection. In grounds for... I
Wait,
object
no.
to that in grounds for
No.
the objection.
Wait a minute.
to happen.
Can you object to an objection? What an idiot. Look at me. It looks like he's a little snarl there. Oh, God. Okay. Sorry, guys.
Mr. Brooks, we did cover many of these topics previously, so if there's new topics, please go to those. I'll give you a little bit of leeway.
Please
To lay
don't.
some foundation, but go ahead, ask your question.
That's
The
what the-
objection is
We
from
already know the
state is
foundation.
overruled. Do you remember the question?
You asked me what was I doing at the park with Corey? Is that your question?
Yes.
We were drinking. I was drinking Mike's Hard beverage.
Do you recall around what time of the evening it was when you and your roommate arrived at the park?
I do not remember. We left where we were staying a little around afternoon. A little bit around afternoon.
Do you recall having any phone interactions during that time when you and your roommate were at the park?
Phone interactions, yes.
Do you recall who they were with?
You.
What do you mean by you?
Darrell Brooks.
Tell him. Tell him. Nothing up there for you to read. No sticky notes, no
Is
post-its.
that usually the name you refer to the alleged defendant by?
No.
I learned later that J is what she refers to. I don't know if it's because initial or I think it's because he's junior, but
Would it be
J.
fair to say that during those phone interactions, there was talk of you guys meeting up. Would that be fair to say?
Yes.
Do you recall, to the best of your recollection, what time that would have been at?
No, I don't remember. It was throughout the day.
I'm sorry, are you making references to the phone conversations being throughout the day?
Yes.
And so at some point, would it be fair to say that you did meet up with the alleged defendant?
Yes.
Do you recall what time that was?
I just told you no.
Good for you, Erika.
Do you recall if you were still at the park during that time, or had you moved locations?
Still at the park.
And was your roommate still present with you at that time?
No, she left. We went separate ways. I stayed at the park, and she went her other way with her friend,
Do you recall who that friend was?
Nick.
Okay. Are you going to come up with any new questions? I doubt it.
I'm assuming, or let me back that up. Would it be fair to say that at some point during the meetup with the alleged defendant, things got a little chaotic? Would that be fair to say?
Yes.
And do you recall if at that point you were still at the park?
When we met up,
Yes.
well, we were at the park for a second, then we drove around.
Where did you drive to?
Around, then me and you, Mr. Brooks, were arguing in the car. We went up this is a street, it's like a hill. Went up there, and then me and you got into an altercation. I got out of the car, walked back towards Frame Park.
Well, wait, again.
Hold on, she's answering your question.
Yeah, let her answer the question.
Where you drove from, go ahead.
Quit interrupting her.
And then I was walking down the street when I left your car. And that's when you followed me, and I walked back towards Frame Park. And you were following me.
Made reference to walk back to Frank Park.
I don't know the exact street name. It was a walk back down the hill. I don't know the exact street name.
Did you at any time, sorry, did you at any time during your travels back to Frank Park, did you at any time notice that there was something going on in the area?
No. When I got to Frame, I was too worried about walking back to Frame Park. When I got to Frame Park after I left it, that's when I realized there was something going on.
And did you ever arrive back at Frank Park?
Yes.
And what did you do when you arrived back at Frame Park?
I called my friend Corey and told her that me and Mr. Brooks got into an altercation. Mr. Brooks was following me. I went back to the SUV, the car, and you argued with me somewhere. I walked back up across the street, and by that time, Miss Corey had walked towards us to meet up with me.
You made reference to you calling your friends.
Mm-hmm.
Do you recall? Well, let me back up a little bit. Did you call your friend Corey or the friend that she had left you to hang out with?
Corey's phone, I kept calling her phone kept finding a voicemail, and I called Nick's phone. He put Corey on the phone. I said Darrell Brooks had just hit me.
I'm gonna back up a little bit.
Oh, please don't. No, don't. You're gonna ask the same
Day prior,
question.
November 20th.
He's gonna mess with November 20th, is he?
2021.
Huh.
Do you recall what you were doing that day?
Well, where I was staying at the shelter at first, I was arguing still with Mr. Brooks all throughout the day. Me and Corey had left, and Corey and I stepped away, and I went back to Frame Park. Frame Park is where I met you at. Me and you also got into argument that day, but we didn't drive around. We're at the Frame Park.
So you're saying that you and the alleged defendant
The defendant, not alleged.
were together the day of November 20th, 2021?
Yes.
Do you recall around what time that was?
I do not remember.
And you stated you were briefly with your friend Corey that day?
Yeah, but she went a whole different direction. She didn't come to Frame Park with me. She turned on a whole different street right before Frame Park.
Come on. She was taking a lot of time.
Do you recall at any time on November 21st of 2021 being interviewed by a Detective Guth?
Yep.
And do you recall giving a recorded report at that time?
I don't remember.
Do you recall if you had given Detective Guth all the details of the alleged incident on November 20th of 2021?
I didn't give him all the details, but I did the next day when I seen him.
We don't have all day. Maybe you do.
funny. Were you aware that it was reported there was in fact no incident on November 20th, 2021?
That's not true.
Objection. Move to strike the answer and the question.
Grounds.
Yeah, he's pushing it again.
Hearsay.
Sustained. I'll strike the question and the answer. The reason stated, sir, rephrase, or
So can I
No.
show the witness the same paperwork that I intended to show?
no.
You've already talked about this.
Why not?
I love.
Not relevant.
Don't you love how he's just challenging her like he's like the king of the world in front of the jury? I know the jury must be so disgusted. Who could not be?
How's it not relevant when that was just testified to? Wouldn't that be opening the door?
No.
Yeah, you need to learn
Next
your
question.
stuff better.
Any reason why?
Crazy, crazy, crazy.
It would be reported no incident happened on November 20th of 2021?
Same objection.
Grounds.
Since that's not in evidence, sustained.
Grounds for the sustain.
She doesn't have to tell you.
The record speaks for itself.
So, upon speaking to Detective Guth during the first interview, do you recall why you were not forthright with information?
It wasn't that I was not forthright. I just didn't tell him everything right away.
Thank you. He's going to try to push that again.
Why not?
I don't know, Mr. Brooks.
When speaking with a law enforcement officer, would it be fair to say that you should be truthful and honest?
I was very truthful. I just didn't tell him everything at once. I told him the next day, Mr. Brooks.
Tell him.
And in the alleged incident on November 20th of 2021, were you injured?
No. Well, you did hit me a little, like a little.
Were you injured?
No, I didn't have any marks on me. Is that what you're asking?
So where were you injured?
By my lip?
Objection. This states the evidence.
Grounds.
I believe the witness understood the question. She answered it. It may stand.
Did your roommate observe any injuries from the alleged incident on November 20th, 2021?
She knew about it. But there's nothing visible on my face.
Do you know if your roommate had spoken with law enforcement about these alleged incidents from November 20th of 2021 and November 21st of 2021?
I don't know.
Did she ever tell you yourself that she was interviewed by any law enforcement?
I don't remember.
Tell him, Erika.
One second.
And we're going to have to wait while he retrieves more papers. Unbelievable.
So what time did you meet up with the alleged defendant on November 20th, 2021?
I don't remember.
Was it morning time? evening time?
Afternoon.
Love the way she's so abrupt with her answers.
Afternoon.
Okay, so He thinks he's so smart and so smug. Look at our friend Zach there. He's ready to pounce at any time he needs to.
And what were you doing prior to the alleged meeting up with the alleged defendant?
Objection.
Grounds.
Asked and answered.
It is.
Sustained.
Yes, thank you.
Grounds for the sustain.
Asked
That's
and
an answer.
When?
Next question, please.
When was it answered?
Come on, Darrell. Come on, ask your questions.
So to the best of your recollection, you can't recall why an alleged incident on November 20th of 2021 was reported to have never happened.
Objection.
Grounds.
Same reasons as the previous objections.
Since facts not in evidence, mischaracterizes her prior
Look
testimony.
at his smug
and
look. Ugh.
Irrelevant.
I object to that respectfully and
Next
ask for a
question.
legal finding of fact
Yeah, good luck with
and
that.
legal reconsideration of that.
No,
ruling.
no.
Denied. Noted for the record. Next question, please.
I'm trying to figure out how something got pulled out of thin air. Interesting.
He's going to act like somebody took his paper. Nobody took his paper. Gosh.
So it would be fair to say that you have a child in common with the alleged defendant. Would that be fair to say?
Yes.
Is that the only child in common?
Yes.
You have any other children?
Objection.
Grounds?
Has nothing to do with the case. Sorry.
Hold on, there's been an objection. Not relevant. Sustained.
Grounds for the sustain?
The record speaks for itself. Next question.
What was the record speaking for itself? I didn't hear it.
Not relevant.
How is it not relevant?
Next question, please.
How is it not relevant?
Yes. Oh, he makes me sick, guys. Oh my gosh, he makes me sick.
The child that you have in common with the alleged defendant, how old is that child?
15.
Do you keep regular contact with that child?
Off and on.
Describe what you mean by off and on.
I'll object.
Grounds.
This is not relevant.
Not relevant. Sustained.
Grounds.
It's not relevant, sir.
She answered it.
Next question, please.
And the child in common that you have with the alleged defendant, does that child live with you?
No.
Objection.
Grounds.
Relevant.
Grounds.
Sustained. Not relevant. You don't have to answer that.
Where did you meet the alleged defendant?
Reno, Nevada.
How long have you known the alleged defendant?
16 years.
You made reference to meeting in Nevada. Do you recall where you met at in Nevada?
No. I remember.
In relation to the alleged incident on November 21st of 2021, would it be fair to say that there's been no contact between you and the alleged defendant?
Since then, no.
That last answer was kind of low. Did you say no?
I
Stop
said
it.
no, not since then.
He's sickening.
So that would mean, assuming, that would mean no contact at all via phone or anything like that.
No.
So my question would be, I don't know if you can see them from here, but do you recognize these pictures?
You need to show those to the state. The bailiff will take them. It's not proper procedure, sir.
See, he's so smug because of the Detective Casey video. He thinks he could just bring his own exhibit in.
I'm going to object to those being shown to witness. They have no relevance whatsoever to this trial.
Yes, they do. And
Sustained.
I'm getting to how they have relevance.
They've also never been disclosed to the state before this moment.
Sustained.
Sustain what?
Not relevant.
They are relevant. It creates foundation,
So, please.
and I can prove that.
I'll take up the issue outside
I'll
the presence of
bet
the jury.
you can't.
Inclusion of this witness, and if need be, bring the witness back in. But next question, please.
And these need to be offered into evidence as well. You stated that there's been no contact.
See that thing with his mouth? Ugh, sickening.
How would the alleged defendant obtain photographs from you if there's been no contact?
Objection.
Grounds.
Suspect not to evidence.
Grounds.
Sustained. Assumes facts not in evidence. Not relevant.
How's it not relevant? Photos just don't pop up out of the blue.
Mr. Brooks assumes facts not in evidence.
Just
And
facts.
this point
I
of
got the pictures
conduct
right here.
after
Facts.
the alleged date of violation here is not relevant.
Alleged violation.
You're
For the record.
correct. After the date charged, the dates that are charged for these allegations, you are absolutely correct.
Thank you. Have you, since the evening of November 21st of 2021, have you attempted to contact the alleged defendant?
Objection.
Grounds.
Relevance.
Grounds.
He
I'm going to
thinks-
excuse the jury. All rise for the jury.
Look at him.
Thank you. Be seated.
Yes, all for funny.
See, the Anna shut up.
Oh, hold on. All right, sir, I'm going to let you make an offer of proof as to why you believe the photographs and the questioning about contact after the alleged incident is relevant.
It's relevant because these were sent by the witness.
It assumes a fact, not an evidence, but
You
what
want
is,
the letter
hold
too?
on. Tell me the basis you believe there's been communication and why you believe it's relevant to her testimony.
It's relevant because it was testified to her first time testifying, and then also by was the last guy, Guth, that he was told that the witness was supposed to be so deeply afraid of me and all this type of stuff. So if you're so deeply afraid and worried about somebody and this and that, why would you seek
Do
to
you
have
want
contact?
to open up the door to the other act's evidence of
That's
you
not
use-
opening.
No.
That's not
Hear
opening
me
the
out.
door.
Hear me out. Oh, yes, it does.
No, it doesn't.
These witnesses have been incredibly careful to abide by my rulings. Sometimes in a court of law, when there are pretrial rulings, the testimony of a witness needs to be said in such a way not to run afoul of that. This witness, Detective Guth, I believe Detective Casey and others, Corey Runkle, and even Nicholas Kirby yesterday, this court has all had to stop them so that they didn't run afoul, or they've stopped themselves so that they didn't run afoul of the court's pretrial ruling on other acts of evidence between you and this witness. And I've been very, very careful to make sure that doesn't come in. But if you keep questioning her about whether she's afraid or not, or why she wouldn't have contact or not, you are opening the door to that testimony. All of my rulings have been made to prevent what could be seen as prejudicial evidence. The standard's not prejudicial. The standard's whether it's unfairly prejudicial. But you can open the door to that, sir.
It's unfairly prejudicial.
Presidential.
I have a document stating that November 20th never even happened, but yet and still the witness can get on the stand and lie on the stand.
Have you turned that document over to the state?
Come on, man. Y'all know that's not right.
It
Y'all know that's not right.
Need to play by the rules, buddy.
Then you need to immediately turn it over to the state right now. It may become relevant, but no one has seen it. When did you receive the document? Hold on. I'm having you make an offer. When did you receive the document?
Okay, but I just want to state for the record, Your Honor, that's kind of biased because the state did the same thing yesterday with creating an exhibit
they
right on the
didn't
fly
create
that
it.
existed. I didn't have.
Fool.
But
That's
then,
not true. That's a misstatement
no,
of the
that
evidence.
is true.
No.
She said it herself.
No. Marking an exhibit is not creating an
No,
exhibit.
not marking an exhibit. She said
We're not going to go down a tangent, sir.
All
right. Worry about what they did.
And I'm going to give you the opportunity
not
to
fair.
make a record.
It's not
Right.
fair.
Yeah,
It's
well.
not fair.
When
Was it
did
fair what you did to those victims?
receive this document that you claim was sent by this witness?
It is not claimed. It's for a fact.
It's a big
Sir,
fat lie.
It hasn't been established yet. I need to make a
So
record.
do y'all want
I
the
wanna
letter?
see
Y'all
the
want the
letter.
email? What?
I want to see the letter,
Okay, so I gotta.
and I want to
so
know
I gotta
when you
bring that in.
received it.
I gotta bring that in.
Yeah, of course, because pictures aren't going to do
Every
anything.
time, this is what I don't get. Every time I'm presenting something that needs to be made for the record and placed in the evidence, it's a problem. But the state can do it, no problem.
It's not, sir. There are proper procedures.
Get
and I
yourself
want
an
you to
attorney.
make a
Proper
record.
procedure.
If you don't
Get
make
an
a record,
attorney.
So
then
what?
you can't make a
It
ruling.
threw people off the loop. They weren't ready for it. They scared of it. That's what it is.
Yeah.
Come on, man.
Get an
Mr.
attorney.
Come on, man. Stop.
When you
Stop
are,
Get attorney.
You aren't
Stop
even
it. You're a
letting me
public
ask the
servant, Your Honor.
questions.
I respect
Get an
your
attorney.
courtroom. I
You don't respect
You're a
anybody.
public servant, though.
Get an
Your
attorney.
job is to be the referee.
Get an
Is it or
attorney.
is it not? You stated so yourself on record that your job is being the umpire.
Your Honor, can I ask Ms. Patterson please be excused?
Yes, you can be excused. My apologies.
My apologies too, but it needs to
Nah,
be some truth.
you don't mean any apology.
Especially when we're talking about stuff that didn't even happen, but they're allowed to get on the stand and say that it happened when they know it didn't happen.
So I'm going to make a record about what
This
he's
is
referring
ridiculous,
to
man.
in count 77.
And what happened to that paper? Because it was on the table. Then
Here
when
it goes
I-
about the
I
paper.
will make a record of a variety of
So who
things.
took my paper?
And you keep interrupting me repeatedly today. I have shown an abundance of patience this morning. I've warned you repeatedly about being removed from the courtroom. And then every time I try to get into it, you, meaning an explanation and make a record, you interrupt, you attempt to divert everyone from what is being done this very second.
I didn't attempt to do anything.
Yes,
Yeah,
you do
you
it
did.
repeatedly, sir.
Whatever.
So you're doing it once again.
Whatever. Just make your record.
The document that Mr. Brooks wanted to show Detective Guth and this witness was a letter sent from the state of Wisconsin to the court regarding count 77. The state sought to dismiss that count, and they have prosecutorial discretion, and I granted the request that the charge be dismissed.
Why was the charge dismissed?
And that's
God, to help
I
you.
can't answer. It was dismissed because the request was made, sir. They don't need a reason. There's an abundance of case law about prosecutorial discretion.
I'm sure his attorneys knew. Get a freaking attorney and ask them. He was told multiple times the difficulties it would be to represent himself, but he was so cocky and certain that he just went on and did it, but then he was still going to just disagree with anything, whether it was right or not. Get yourself an attorney. I wouldn't have said as much as she's said to him, but I don't know. I'm not an expert, so.
And they chose not to pursue that. My guess
Your
is
Honor,
maybe
with
to
all respect.
simplify things and to keep this tidy. I don't know. You know what? I'll indulge you. Attorney Opper, would you like to provide a basis for why the state sought dismissal of that charge prior to the start of this trial?
Yes, Your Honor, because as Ms. Patterson just testified a short while ago, she did not have any visible marks or injuries from that event. And we did have the photographs of her injuries. We did not want to confuse the record as to whether or not there was a battery that occurred on November 20th.
Your Honor, I object to that. What does the letter read?
Psh, object.
You have the letter. You showed it to
I
me, sir.
and I've been trying to find it ever since I came back in here, and now all of a sudden I can't
And now
find it.
you're impugning, though, like somehow you're impugning the integrity of this court,
No,
of
I'm
the
not.
bailiffs of this state.
Yes,
you're
you are.
accusing, frankly, everyone
Did I
of
point
moving
the
your
finger?
papers.
Did I point the finger
At
anyone?
everybody.
Did I say anyone did anything?
Not directly, but indirectly you did,
So
sir.
how can you make the
made-
assumption that I'm saying?
It's not
Can
an
I please
assumption,
make
it's a
the
fact.
record Without you
Yes,
interrupting
you
me?
may. Yes, you may. I apologize.
I appreciate that, thank you.
I don't appreciate it.
But you made repeated comments, sir, about I can't find my documents, I don't know what happened, things of that nature. When you came back out, you took multiple minutes before you even asked your first
Yeah, no
question
kidding.
of Ms. Patterson. And if I need to, I'll have a bailiff put on the record that no one touched your table.
Your Honor, did I say anyone touched my table?
Oh, you know what?
You implied it,
implied it
But did I say that?
vigorously.
I never
You
said.
stated it implicitly.
I
Yes.
never asked the bailiffs, hey, did anyone of you touch my
Because
table?
you know nobody
Never
took
said
it.
that to them. I just said I can't find my paper, which is the truth.
And the
I'm
way
looking
that
down.
you said it, like,
I didn't point anyone
With
out
a-
though.
and like,
lying
well, that's
again.
kind
That's
of
fair.
interesting.
I don't
I don't
think
have a
that's fair
document
to
that was
assume.
just on my table.
Lies,
That is what
lies,
you said.
lies.
That's
Words
what
to
I
that
said,
effect.
but I did not point the finger at anyone.
So,
You
I
pointed
just
at
said if I came
everyone.
in, Your Honor, with
you've
all
been
respect,
given,
No, you have no
I just said
respect.
if I came in and said, hey, one of you moved something off my table, or
You
if I
might
would've
as well.
directed that towards the state, or if I directed that towards the clerks or something like that, then that would be more of a validity to what you're saying.
I need to
It's
continue
still-
with the record, sir. It's very apparent to me, sir, that every time, I can't say every time because that would be an absolute, but many times throughout this trial, and especially the last 2 days, when the court makes a ruling that you disagree with, or I want to make a record about some behavior of yours, or a further record about a ruling that you that was not in your favor, that you start peppering me with questions or comments statement, you question me about the law, you ask is it verified law. It is, from my perspective, a clear attempt to kind of turn us in a direction away from what we're doing, perhaps even to stall and to delay.
I'm sorry.
That's my perspective. That I'm making a rule.
Just shut up. Let her talk.
I mean, because it has no validity.
Oh, it does have validity.
So, I am trying to make a record outside the presence of the jury about a line of questioning you want to ask Ms. Patterson. Now, I've reviewed repeatedly up on the bench 90608 and 90616, which are two of the primary ways you can attack credibility. I've referenced one of those previously. 90608 is evidence of character and conduct of a witness. I'm not going to read through it all, but it's limited to character for truthfulness or untruthfulness. It's not specific instances of conduct. It's character evidence, which frankly wouldn't even come from the witness who's testifying. All right, then there's the statute on bias, 90616. All right, and none of the questions as I heard them went to a permissible topic under bias of witnesses. You generally said credibility. You did not give me any further explanation as to why you believed it was relevant to credibility. Now we have you claiming that there's some document that was sent by the witness after the charges were filed that apparently contained photographs. And you can clarify the record momentarily when I'm done, that you believe goes to the credibility of this witness. So I need to ask a few questions about that, sir, to determine whether it has relevance to those issues. Number one, when did you receive this letter?
I received this multiple letters, actually, over a period of time. It wasn't, I referred to this one because this one had the pictures. But
and why do you believe it was from Ms. Patterson?
To answer your question with clarity.
Thank you. Does it have a date on it? The letter?
No, I didn't bring the letter. I brought the pictures.
Because there is no letter. There's no letter.
My interpretation, I thought showing the pictures would be okay. How did I get these?
Very poor interpretation. They could have been from anyone. The best thing would be a letter signed by her with a date on it. But he didn't bring it because there are no letters.
So my mind was saying, show the pictures.
Yeah, that's the problem.
They didn't come out of thin air.
Your mind, that's the problem.
The witness knows that they sent me the pictures. They know that.
Well,
you're lying.
Again, it assumes facts that aren't here. You're assuming this witness sent it. I don't know. But even if she did, what relevance does it have to her credibility before this jury?
It goes to the credibility because she's put on this facade of being so afraid of someone, but yet still, you know that we're not supposed to have contact, but you still sneaking behind and saying, oh, I wonder how you're doing, and oh, this and this and that. Oh,
I don't think she's ever said she was afraid. I think that was the officers who may have stated that, but I don't believe she ever said that. She specifically said today when you asked her why did you, it was either why did you go back or why did you have, I'll look at my notes, and she said, I don't know.
It was why weren't you forthright with all the details? That was the question.
So again, I'm going to ask you, even if this letter's from her, these pictures are from her, how does it relate to her credibility before the jury?
Who else could it be? Who else could these
Oh my
pictures
gosh. You expect anybody to believe that?
I'm going to ask you point blank, did you get a letter that's signed from her?
I got, what do you mean signed? No
How
one
do you
signs
know?
letters.
What's your belief?
No one signs letters.
That they are from her.
I have multiple letters from her.
You're not answering my question. Why do you believe the letters are from Erika Patterson?
Because they were sent from Erika Patterson.
That's convincing.
Were they signed by her?
What do you mean signed?
Did she write her name on the letter? Was it the content of the letter? No, I'm not kidding you. I need to make a record, sir. You're making a statement that these letters are from her and that they're relevant to her credibility.
Your Honor, I'm gonna go out on the limb here.
And I'm asking you why you hold that opinion.
I'm gonna go out on the limb here and assume, which I know is true, you've never been in my position. You've never been in jail. So you've never received a letter from someone writing someone in jail.
Okay. I object. That has to be the stupidest thing he says. Even if they haven't been, they know. I know because I know people who have been in jail, prison, who I have written to. And my address was on it, the date when I wrote it. I signed my name. They wrote me back. They signed their name. So I don't know what the hell he's talking about, acting like you can't sign a letter. If somebody else out there has heard of some such thing, please let me know. But I do not believe that because I've written several different people in jail, prison before, and I've signed my name. It would be easy to go back and check that. So right there, he is lying. There is no letter. No letter.
No one is gonna when you
You're
say
not
to
answering
me,
my
when you
question,
say to
sir.
me,
See,
What's
changing
your
the subject.
basis why
Changes
you
the subject
believe
all the
they're from
time.
Miss Patterson? Is there some information in them that only she would know? Did she sign the letters? Is it penmanship that you recognize? Why do you believe they're from her as opposed to somebody else sending you information? Could be your mom, could be, I'm just saying, could be anybody else. You gotta answer my question. It's called an offer of proof.
But you still gotta understand why this is mind-boggling to me. Like how I got a child with this woman. Why would I not know her handwriting?
But you have to lay a foundation for these letters, sir. That might be through your own testimony. So that I'm trying to figure out why you believe they're from her. Not all this other stuff about I'm in jail and I have a child. I need to know. It's called an offer of proof.
Are you serious?
What do you
Dead
believe?
serious.
Why do you believe they're from her? I am serious.
Because they're from her.
The other thing,
like how else?
I'm sorry. The other thing I noticed too, because I've dealt with kids before, when their voice gets all high pitched, lying. It's like, why wouldn't you bring the letter? Bring the letter, and then that will prove your case.
How else am I supposed to answer that?
I've given you a few reasons why it would lend to that opinion.
So it has to be put in a legal
The
term.
bottom line is I need the letter. So
No,
if
she
you're
just
gonna
needs the
question
damn
her on
letter.
that, the state absolutely has a right to see the letter. So you need to provide that letter. The bottom line is I'm not going to allow any questioning without having that letter. So the state has the ability to question you about that.
Look at that
question
face.
This witness and to look at the veracity of what your claims are here. So when I may take an early lunch. If that's in your cell, then you can go get it and bring it. But without that letter, I'm not allowing this line of questioning. Do you have the letter with you in court?
I just said no. How many times I got to say the same thing on record?
You know, sometimes, sir, I don't hear what you say because you interrupt me so much or you answer quietly. And I'm taking notes and I'm focused on probably a dozen things at the same time.
But if I say something under my breath, everybody seems to hear it.
We do hear you under your breath.
In a quiet courtroom, yes, you can hear it very clearly.
Everybody assumes that it has to be disparaging.
It is.
Once again, you're doing this tactic.
Because
it's
not a tactic, it's facts. It's facts.
To some other reason.
It's facts. Because I find it hard to believe that
I'm gonna
all of a sudden nobody hears what I say.
I'm going to let the state make a record of why they believe it's
objectionable. You shut up and let the state speak.
Do that. I've given you multiple opportunities to
tell we've heard enough of you.
I didn't get these pictures from nobody else. Why was somebody else?
The record will reflect you have 2 pictures that you believe were from this witness.
That I know is from.
That you believe.
Sure.
That I know.
That you believe.
All right. I'll ask the state their position on all of this.
Okay, I'm stopping for a moment before the state gives their answer or their take on this whole picture letter, alleged letter situation. My thing is, he brings 2 photographs in, and he says they're sent by Erika Patterson, and he keeps talking about a letter, but that nobody signs a letter. What is he talking about? I've already talked about my thing about what I said about. Of course, people sign letters. I don't think there is a letter. But he's bringing 2 photographs in, and he's just saying, well, why? Because it's from Erika Patterson. So he brings in 2 pictures, and everybody's just supposed to take his word for it, that Erika sent them. Well, of course they're going to need a letter. But he's so emphatic that, who else would send them? My guess is probably Mama Dawn did. Who else? But probably Mama Dawn. That's my guess. But it's just so funny to me that he thinks that he's trying to equal what he's doing to what Attorney Opper did when they finally brought out the rap video to prove what Detective Casey was talking about, and identifying him. It's a totally different thing, as of course we all know. But that is why I just had to stop and say that for a moment. And plus, actually, before I started continuing to record this, I had to step away because it was getting me so aggravated, even though I know he's up under the prison for 1,000+ years. It still really gets me worked up, I guess, because of the validity, as he would say, or somebody said validity, or just the massive destruction he caused to people, and he doesn't it doesn't faze him. The only person he's upset about is himself. I think that's what it is, and then when people lie, it just makes me crazy. But anyhow, let's see what Zach has to say. I'm sure it's good.
My position, Your Honor, is that these pictures, first of all, should not be admissible. 1, because of a discovery violation. We've never seen them before. 2, because we have reason to believe that he did not get them from Erika Patterson. He is on a jail phone call talking to his mother, Dawn Woods, about Dawn Woods sending these photographs to him. Now,
That's a lie.
You see that? I love it. See? That's it. Dawn, that is that easy. I mean, without any letter. And I want to point out, hopefully I can capture this, but most of y'all will know this, but one of the victims, Leanna Owen, who I think she went by Lee Owen, was one of the dancing grannies who was eliminated by Darrell. And I've noticed, I know I've brought them up before, her 2 sons that have been in court, I'm sure the whole time. There's one of them right there, and it should show the other one, because once Zach starts to tell about all of Darrell's stuff, they look at each other like, it's satisfying for me to see these victims who have lost their family derive some satisfaction from dumb Darrell. So hopefully I think we should be able to capture it pretty well. Okay, here we go.
I've checked
Let
that.
the state make their argument without interruption, sir.
That's a lie, though.
3, I believe that these photographs are designed to make a suggestion to the jury that Erika Patterson is a bad mom. I think that is what the defendant is trying to do. And if we're going to go down that road, then we would be forced to counter that claim. First of all, it doesn't make her an incredible witness, if it's even true. And second of all, if we go down that road, we would be forced to counter that claim by pointing out that not only does the defendant not live with the child in question, he doesn't live with any of the other children that he has, he impregnated Erika Patterson when she was a minor in Nevada,
Ooh,
and for doing so, he
watch
was
these
convicted of
guys.
statutory sexual
Watch them.
seduction.
Keep watching them.
Pled guilty in March of 2007 to that felony offense and is a sex offender on the registry
Ooh,
as a
sex
result.
offender.
So if there's any causation
Do you see that?
would lead to Erika
I love
Patterson
it.
being a bad mom, Mr. Brooks has a direct role in that causation.
And that's
Furthermore,
not object to that,
I'm not
because
done.
that's a lie.
Let him
Because at the end
finish.
of the day,
Let
if
him
we
finish,
gonna open the door
Mr.
on that, no,
Brooks.
since he want to make a record
Oh,
and not
Lord.
be accurate, so let's be accurate all on the record since you think you know so much.
Once
So
again,
we can
Mr.
open the
Brooks
door
is
on,
being
we can
loud,
open the door on how old she told me
disrespectful,
she was when we met.
interrupting.
We can ask that question
He is
too then.
over the
Did
top
you ask that?
animated
Do you
right
know
now.
that?
Mr. Brooks, I'm ordering you to sit down and to let the
No,
state
that's
finish.
not. I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
Right. Under Illinois versus Allen, I've warned him repeatedly. He's being removed from the courtroom. And you know what? Let me dial that back. We're just going to take an early lunch, 1 hour. We'll be back. And unless he brings that letter, and he can show it is inadmissible, he will not be questioned. And under 906.11, I will declare the cross-examination closed. Thank you. We're in recess. 1 hour.
Get your facts straight. So let's open the door on all of it then, so we can get all of it on the record. Since you think you know so much. Did you know she said she was 18 when I met her? Did you know that?
I find that pretty funny because how many men have said that? She told me. Well, okay, so what if she told you? It's still their responsibility to make sure of how old the person is. That is so lame. And I'm glad I was able to take a break away from it because, and then come back and then see that and see Lee's sons, you know, get some satisfaction and say, yep, this really was scum, you know, this guy is scum. But, so I think now let's see if he's going to be able to get a letter. But it sounds to me like, you know, somehow those pictures got to Mama is what I think. Because, no, Erika doesn't want to talk to him. Okay, so we'll move on to the next.
Mr. Brooks in the other courtroom so that I could make an adequate record without interruption. We are on day 15 of trial, and today has been a rough morning to say the least. We are in the stage of this trial where Mr. Brooks has the right to present relevant and probative evidence and to call witnesses. And I have done my very best to honor his rights in that regard. Part of this morning dealt with his, from my perspective, disagreement with how I, yesterday and in the days preceding that, set up what I thought was a very reasonable way for witnesses to be called into this courtroom on his behalf. Going back to when the state offered to, serve subpoenas on his behalf and talk with or coordinate with these witnesses to come into court. And yesterday, I wanted to narrow things down a bit, as is my not only right, but frankly my obligation under 906.11 to make sure that there is an effective presentation of evidence,
Oh, Lord.
And exercise reasonable control over the mode and order of interrogating witnesses and presenting evidence so as to do all of the following. And let me just back up a moment, because I think it's worth putting into the record once again the full language of 906.11, which is entitled Mode and Order of Interrogation and Presentation. Number 1, control by judge. The judge shall exercise reasonable control over the mode and order of interrogating witnesses and presenting evidence so as to do all of the following. Make the interrogation and presentation effective for the ascertainment of truth. Avoid needless consumption of time. Protect witnesses from harassment or undue embarrassment. The next section, a witness may be cross-examined on any matter relevant to any issue in the case, including credibility. In the interest of justice, the judge may limit cross-examination with respect to matters not testified to on direct examination. The next section, leading questions. Leading questions should not be used on the direct examination of a witness except as may be necessary to develop as a statute that guides what I do, not just in this case, but in every case that comes before me for trial or even a motion hearing. And in my almost 11 years on the bench, I've presided over dozens and dozens of cases that have gone to trial. To say that this has been the most challenging of my career would be an understatement. I've done my best, I believe, to be fair, to be unbiased, to protect the rights of not only Mr. Brooks as it relates to this trial, but those of witnesses, those of the victims, and of course, last but not least, the jurors. Prior to the court taking an early lunch this morning, a couple of things happened that I think are worth making a further record about. Going to the beginning of this morning, where it is true, I did not do my usual practice of asking if there were any preliminary issues that the parties wanted to address. In my mind, I wanted to get to the witnesses. We are at that stage. I knew there were a number of witnesses to be called, and I wanted to ensure that it was done effectively for all of the reasons that are stated in 906.11. And I thought it was reasonable at the time to simply take up issues dealing with legal matters at a break. That's why I brought the jury in. During the jury coming in, Mr. Brooks continued to talk, make statements. The record speaks for itself. I'm not gonna, frankly, I couldn't tell you everything that was said at that time. At this point, I think it's important to note, though, it's the tone, the demeanor, the decorum, or frankly, the lack thereof for many days on end throughout this trial. It has become apparent that when the jury comes into this courtroom and leaves this courtroom, that Mr. Brooks makes disparaging remarks about the integrity of this court, of these proceedings, and of other parties in the courtroom. He repeatedly references things such as subject matter jurisdiction, which there is a written decision that I have filed in this case. It is very clear this court has subject matter jurisdiction over this case. This is not a civil case. This is not a case in federal court, for example, where subject matter jurisdiction sometimes becomes an issue for things like whether there's a federal question that's involved. Every now and again in a criminal case, subject matter jurisdiction is a type of issue that comes up, but not under the circumstances here. I'm not going to rehash everything that's in my decision. I stand by that decision. The record has been made abundantly clear that Mr. Brooks does not believe this court has jurisdiction. His objections have been noted, well documented by the record that's being taken down. I know from my experience, not only as a judge, but as a litigator, that once that objection is made, it's preserved. I even stated at one point, I think there's a standing objection. I will note that for the record. Mr. Brooks continues, in my opinion, to bring this issue up in front of the jury to distract, to delay, and to call into question the integrity of these proceedings. Frankly, maybe to create an issue on appeal if he is convicted. I brought him, I should state it this way, he is not in this courtroom presently because on day 15 of this trial, and specifically this morning, right, we have a history of disruptions, delay, interruptions, disrespectful behavior, the common courtesy I think that just as a human being, we all would expect have not been followed. It's evidently made, let me restate that. It is evident to this court that when there is a ruling that Mr. Brooks disagrees with, whether it be an evidentiary ruling, whether it be on subject matter jurisdiction, whatever it may be, that he has a pattern now of directly confronting the court, asking for, is that verified law? Can you prove that? Is that an actual law? He starts debating the topic once again, or he will even try to further turn us away from that by bringing up another topic. For example, just today, when the issue came up about this letter that he claims was sent to him by Erika Patterson, and I asked repeatedly for an offer of proof rather than answer the question directly, Mr. Brooks instead started talking about an exhibit the state offered into evidence yesterday. And from my perspective, he doesn't address the merits of the issues that are before this court and then tries to divert things down a different path, whether that's to delay, to disrupt, or just simply be discourteous. I think all of those words would be an accurate description of what is happening. That was one piece of, or one objection or series of objections that I actually went off the record. Not off the record. I actually dismissed the jury in order to try to get an offer of proof from Mr. Brooks. And as that exchange went on, it got, from my perspective, he got louder, he got more disrespectful. I think it's fair to say his behavior was volatile, and it's because of that that I called an early lunch. And it's because of all of those things. Even when I attempt to give the warning that he will be removed upon further behavior, he immediately interrupts and says, "Are you holding me in contempt?" A very clear indication to this court that he is attempting and trying and actually disrupting the proceedings so that I can't make an accurate record. Like I said, it's challenging. That is why he is in the other courtroom muted, so that I can make the record. And I will confirm with my clerk and the bailiffs. I should have done this at the beginning, but I believe, thank you, my clerk did confirm that they can see, they can hear, we can see as well. It is this court's opinion that Mr. Brooks is blatantly pushing the limits of what I have tried to establish in terms of when to call witnesses, how to call witnesses. He pushes the limits on asking questions that are not probative, that are not relevant, or that directly contravene a prior ruling by this court related to other acts evidence. That ruling that I made was to the benefit of Darrell Brooks, not the state, Darrell Brooks, the defendant. There have been multiple witnesses who have themselves stopped, basically looked at me and, can I answer that question, basically? Is there nonverbal communication to me? Or some have actually said, I don't think I can answer that. There have been other witnesses where I've stopped them from answering so as not to bring in the other act's evidence. The most recent of which occurred this morning with Erika Patterson and the repeated questions to her related to either information she did or didn't give the detective when the detective spoke to her on two separate occasions. There's been other questions throughout the trial to, I believe, to Detective Guth directly and other witnesses who had information about why that may have been the case. But this witness, I think, has been very, very careful to not run afoul of the court's prior ruling. That leads to the evidence claim by Mr. Brooks that he has related to a letter and photographs. As I indicated before the break, I've looked at both 906.16 and 906.08. Those are generally two of the statutes dealing with character evidence. That would be 906.08, 906.16 deals with bias. From my perspective, the questions that were actually asked and answered about do we have a child together? Well, he didn't ask it quite that way. I'm summarizing, but regarding their common child, regarding whether he sees the child on or off, where they met, things of that nature, are solely to attack her character, as a mother, which is wholly improper. The only character evidence that would remotely be allowed under, at least for a witness under these circumstances, would be character for truthfulness, which would not even be from this witness. It's typically another witness comes in and testifies to that, and only about opinion evidence, their opinion of the person's character for truthfulness. Under bias, 906.16, I didn't see where it also related to her credibility. It says, for the purpose of attacking the credibility of a witness, evidence of bias, prejudice, or interest of the witness for or against any party to the case is admissible. Again, simply attacking her on her motherhood. That's my perspective. I did not receive the answer to the repeated questions I asked regarding the offer of proof and this letter that he claims was sent by Erika Patterson, and then the photos. The issue as it relates to this witness is a single charge in the case. It is a battery charge with a date of violation that is alleged to be November 21 of 2021. To allow Mr. Brooks to ask the witness about contact after that point in time is not relevant. He has not given me any reason as to why it's relevant. The state also, I think, rightly points out that if those questions were to be answered by Erika Patterson and other questions along those lines that were questions that were objected to by the state and that I sustained, Mr. Brooks would open the door to what only could be described as very damaging evidence against him related to
He doesn't
the
get
other acts
that.
evidence,
He does not get that.
related to whether he has a relationship with the children or not, and frankly, a topic I am not going to open the door to. I'm not going to allow. It's a side issue. It is not relevant. It is not probative. But certainly one could argue, based upon the questions, topics that the door could be opened to. It is my duty as the judge assigned to this case to ensure that the trial is fair, that relevant and probative evidence comes in, and that it is done so in a way that's effective and efficient for the presentation of evidence, including the testimony of witnesses. And so I'm not going to allow questions related to the children in common or child in common, at least any further, between Mr. Brooks and Ms. Patterson, when they met, how they met, the nature of their relationship now, whether there's been any contact between them since he was arrested and going forward. Because nothing that I've been presented with would suggest it relates not only to relevant and probative information, but even to her credibility as a witness. I will give Mr. Brooks a final opportunity to make an offer of proof as to why he believes my decision is wrong.
This should be good.
that needs to include an offer of proof as to why he believes this letter is from Erika Patterson and why it's relevant to the issues in this case.
Okay, let's see that letter. Let's see the letter. He doesn't have a letter. Let's look at him. What is he even looking at?
He came in to the courtroom this afternoon and is not in here but in an adjacent courtroom. I want to make some additional findings as well and kind of just tie up a few loose ends for the record.
Like he's a liar, an
As
idiot.
the Supreme Court in Illinois versus Allen stated, it is essential to the proper administration of criminal justice that dignity, order, and decorum be the hallmarks of all court proceedings in our country. The flagrant disregard in the courtroom of elementary standards of proper conduct should not and cannot be tolerated. Trial judges confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. This court has utilized an adjacent courtroom with superior audio and video capabilities that I believe are the functional equivalent of being present in this courtroom. Mr. Brooks's behavior today alone was disruptive. I would absolutely characterize it as stubbornly defiant. It was interruptive, and it certainly aggravates the proper administration of the criminal justice system, of this trial. There was nothing dignified about it. There was nothing orderly about it.
Yeah, it's an understatement.
He even shows respect for that. I'm not looking for any further input on the issue of removal or any further record. I wanted to make that record without interruption, which is why Mr. Brooks was in the other courtroom.
We all thank you for that.
When we come back to this courtroom, I will ask Mr. Brooks for an offer of proof. He will be brought in.
Oh, Lord, please no.
So we'll go off the record for that momentarily. An offer of proof, if he wishes to do that, related to the letter and further questioning. I also want an offer of proof as to what probative and relevant information Ms. Patterson will be testifying to based on his direct examination. This is a witness who was called by the state initially. This is a witness where Mr. Brooks had a full and fair opportunity to cross-examine her on a prior date. He was allowed to call her himself. The vast majority of the testimony today has been a rehashing and a representation of her testimony from the other day. I'd have to look at my notes for the date. October what? October 7th, I believe she was the third witness. We did not glean anything new, probative, or relevant through the course of the questioning today. Because he's had a full and fair opportunity to already cross-examine her, because he's had a significant amount of time this morning to question her, I will require that offer of proof, and then I will make a decision whether any more questions will be asked of the witness. At this point in time, does the state anticipate any cross of Ms. Patterson? But I'm going to ask that when we come back, when everyone is here. With that, I am going to take a very short recess to have Mr. Brooks brought back into this courtroom so that we can continue with testimony and evidence. Thank you.
This should be good.
Back on the record, I've been advised that Mr. Brooks does not want to come over to the main courtroom.
Oh, he doesn't?
Mr. Brooks, I'm advising you, you are invited back to this courtroom.
Oh, don't invite him.
It is my sincere hope that you want to come back here. I see you're reading something, but we are at the point in this trial where you have a witness still on the stand, obviously figuratively at the moment, not literally. I'm going to ask you if you are ready to answer my questions from previously and also to let me know whether you are asking to stay in that courtroom.
Where's his letter? Where's the letter? He could have gone
Been
back to
advised
his
you can hear and
son
see.
and get. There's no damn letter.
Mr. Brooks, we are on the record. I'll go through the topics one by one. You are in the other courtroom. You are invited back here. Would you like to come back here? Yes or no? The audio is on. Would you like to come back to this courtroom, sir?
Oh, shut the hell up about
So I'm finally unmuted.
Oh,
Been unmuted
please.
for a while
Such
since
an
I came back
ass.
on. My understanding, sir, is you'd like to be in that other courtroom. Is that true?
Waste everybody's time a little bit longer, like you love to do. He does have some sort of hairline going on, doesn't he?
Record to reflect, he's putting on the headphones.
What's going on?
What's going on?
Mr.
So
Brooks?
rude.
I'm inviting you back to the courtroom. My understanding from a relay of information from the bailiffs is that you don't want to come back here.
I ain't say nothing.
All right, are you ready to come back
He
then?
lies about every single thing.
Not if I'm just gonna get held in contempt again.
I didn't hold
Here
you in
we go
contempt
with the contempt.
Then why am I even over here?
so that I could make a ruling and make a record without an interruption pursuant to my authority in Illinois versus Allen.
So did you make your record?
I did.
Am I ever gonna get a chance to make the record without being interrupted?
Mr. Brooks, I'm asking you, the first question is, do you want to come back into this courtroom?
Not if you're gonna hold me in contempt.
Sir, I
I
need
don't
to
want to
continue with the trial.
I don't
So
wanna
if you
keep being
don't
held in
answer
contempt.
yes or no, then I will presume you want to be in that courtroom and you'll, by your conduct, waive your right to be in this courtroom.
By what conduct? I didn't consent to
By
being held in
failing
contempt.
to answer my question, sir. So I'll ask you again.
Are you gonna hold me in contempt? I don't want to be held in contempt.
I will ask you again, sir. Would you like to come back to this courtroom?
I'm supposed to be in there anyway.
Not when you
So
act like you
twice
do.
now I've asked him. He has not answered a yes or no. Mr. Brooks, I'll ask you a third time. Would you like to come back into this courtroom?
Yes, if you're not gonna hold me in contempt.
Given his yes, I will close the courtroom. He'll be brought over, and then we'll continue when he comes into this courtroom. Thank you.
And for the record, I do not consent to being called that name.
Oh, for gosh sake, that's so lame. I really wish she wouldn't bring him back. Does she? What's he saying? We can hear what you're saying perfectly clear. Hold me in contempt. Yeah, he just throws that contempt word to make it look bad for an appeal. But I mean, they're going to be able to read the records and see all about his shenanigans.
All right, let's take up the issue of the letter and the photographs and your offer of proof, sir, if you have one.
I don't need no offer proof.
I'll ask you a second time. Do you have an offer of proof to
go
provide,
past all
sir?
that. We can go past all that. I don't need to ask them questions. It's too much of an issue. It's too much of a problem.
And you know what else it is? He doesn't have any damn letter. He has nothing new offer of proof because there is no letter. And then probably he got the pictures from Mama. But don't you love how he does it? He always likes to act like a martyr. Oh, man.
Mr. Brooks, I'm going to ask you for a third time. Do you have an offer of proof
I
related
just said
to
no.
the route?
I just said no. I just said that.
Because you don't have a
All right,
letter.
thank you. Then based upon there being no offer of proof, then my decision stands. As to the continuation of the examination of Ms. Patterson, I would like an offer of proof as to what you believe her probative and relevant testimony will be from this point forward.
I mean, I don't know how she's going to answer the rest of the questions. There's not that many questions left. I was almost done.
Yeah, sure.
What topics generally were you going to question her about?
I guess I'll have to look in here because so much that happened since over the past hour and a half or so.
Wah. All because of you.
From the first date that she testified and from today? What new topics
I
will
don't
you be?
remember everything she testified to the first time.
Just, you know what? You got nothing.
Mr. Brooks, this is your opportunity to prevent relevant and probative evidence, but under 906.11, she's already been questioned now twice by you. So what new topics do you intend to question her about when she comes back on the witness stand?
What do you mean by new topics?
Topics that you haven't already covered.
What, to pursuant to the police report or something? Is that what you asking? I don't understand.
I'm asking you. I'll ask you once again, sir, give me an offer of proof as to what you believe your questioning will be as to Ms. Patterson going forward.
And you say related to topics, right?
You can just give me the topics. I think that's fair.
I wanted to ask questions about the police reports.
Mm-hmm.
That was the last few questions. That's why I'm saying it was only...
Is it a statement that she wrote?
You don't know what the heck to say now.
I don't know if it's a statement that she wrote in here.
Do
Possibly
you see a written statement with her signature
I will
on it?
have to go through all the paperwork.
Is there a written statement from Ms. Patterson? It's my understanding Detective Guth spoke to her on both occasions. Is that right?
Yes, with Detective Barron, with him on the first occasion. Detective Barron wrote that first report. Both interviews were also recorded.
Previously provided with discovery?
Absolutely.
You got nothing, Darrell. Just give it up.
What about the police report, sir? Do you want to question her about so I know with specificity?
Oh, I'm looking at it now.
Mm-hmm.
How many officers did reports? Because it seemed like it's more than just two.
You shouldn't be asking anybody
This
anything.
paperwork is more than two.
Mm-hmm. Nobody's going to answer you. You need a lawyer. Get your lawyer.
May I have a bill and show me what Mr. Brooks is referring to? I can maybe help him try and explain, but
Gosh, he's being too nice. Basie's going, what are you doing? Don't help him.
I can't find a first place to that, but whoever that officer is right here.
Oh, gosh.
I have to snatch it.
He said you don't have to snatch it. Like the officer snatched it. Okay, sure. Okay.
so I've got pages 2 and 3 out of 6 from Detective Barron's report under Waukesha Police Department.
Sorry, guys, I'm trying to adjust this so we can see
21-04753. This is one of the two reports we've been talking about regarding the statements that
He doesn't
Patterson gave
have
to
all of his
detectives
stuff
on
together.
November 21st,
I do apologize
and then
for
on November 22nd.
moving this. I'm
This
just
is
trying
the
to
first
do
statement.
it to see everybody. Try to.
Is that the officer you just said?
Yes.
See, and he
What
can.
about that report do you want to question this witness about?
The report is not in order, so again, as I
He's
stated,
so complicated. And the thing is, he bitches and moans about the prosecution. And maybe because they were like, we know we're going to win. This dude is not going to win. But, I mean, they're doing the right thing by helping him. And he doesn't even care or appreciate it. It really is all about him. All about me. All about little Darrell.
before I would have to read it.
You need to get
Brooks,
your
I trust
shit
that you're
together.
prepared. These are your witnesses. So
He is
what
not prepared.
What about that report do you want to question Ms. Patterson on?
Your Honor, I just stated 3 times I would have to read a little bit of this to form the question.
Yeah, but you should be prepared.
Under my authority, under 90611, then, and given that this witness was initially called by the state, there was a full and fair opportunity for cross-examination by Mr. Brooks at that time, and they had ample time this morning to
Yep.
question her. I will
Sure did.
declare that his questioning of her to be closed. I will bring the
Yes.
witness out on the witness stand and then we'll bring the jury out, and then I will simply ask the state if there are any questions, and then we'll move on from there.
Just so I understand what he mean by close.
You're done.
I'm not allowing you to ask her any additional questions, given your full and fair opportunity that you had previously when she was called by the state, and given the opportunity you had this morning and your failure to identify for this court any probative and relevant information that she would testify to about what's in that report.
Yep.
How do I? First of all, the report isn't even in order. So
Doesn't
I would
really
have
matter.
to essentially read at least some of it to even.
Yeah, but you're not prepared. And you know what? You're just bringing her there to control her and make her squirm and make her miserable. You might as well realize today was your last day to do it. So say bye-bye. No more control over her. Thank God for poor Erika.
And ask
Mr.
a
Brooks,
question.
this is your witness. I expect that you will be prepared and you will not cause delay by any lack thereof.
Mm-hmm.
So I'm bringing the witness out, the jury will come out, and you will not have another opportunity to ask any additional questions unless the state asks questions on cross-examination.
So what is we bringing the witness out for?
I
then,
have
if
to do
can't-
that in front of the jury.
Man,
If you were a
I object
lawyer,
to that ruling too. Can you?
you can't object to that. If you were a lawyer or had your lawyers, you would know how things run like you think you do, but you don't. So I am relishing this moment, and I hope everyone else will relish it along with me. Although he's going to end up taking us off again, but we can enjoy this moment.
Can you give me a lawful law why?
Your objection is
Oh.
noted for the record. If you start interrupting me when the jury comes out or make any commentary, you will be removed to the other courtroom, and that's,
So I'm being held in contempt again?
Here we go.
no, it's not contempt, sir. It's a finding under Illinois versus Allen. It's a warning that you
so
will forfeit your
lame.
So I
right
might
to
as
be
well just have just
No
stayed
such
over there.
contempt finding.
I might as well have just stayed over there then if I was
Mr.
going to get held
Brooks,
in contempt.
that decision is for you and you alone to make, and it is based on your conduct. If you're going to
Just take me over
continue,
there. Just take me over there because I'm not finna get held in contempt for nothing.
I have not held you in contempt.
You did.
You're
You're
a mis-
attempting to hold me in contempt. That's what that is.
No, that's not contempt.
So is it civil or criminal?
Oh my God. This
Why
is
am I
so
being held in contempt?
I'm
That's
going to
the-
keep
that's
you
the
in
whole-
here because
that's the whole
you're
reason
going
I
to need
didn't
to
wanna
call
come.
the next witness, and I'm going to need
Your
to
Honor.
bring you over in any event.
That's the whole reason why I didn't want to come over here because you was going to find a reason to hold me in contempt.
Well, I'm finding a reason, and it's not contempt, but I'd find a reason to remove you based upon your disruptive
Well,
outbursts.
then remove me if
and
that's
your-
what you want to do. Remove me then.
I don't want to do it, sir. I
Obviously
want
you
in
do.
this courtroom.
Obviously you do. You brought it up before we
I
can even
want-
get to.
All right. Mr. Brooks has forfeited his right to be present in this courtroom for the remainder of this witness. Even
So
though
did
it will be
I
short,
actually forfeit that right?
you have forfeited your right to be present.
Sure as the hell have.
And how did I forfeit that right, Your Honor?
All right, we're going off the record so that he can be removed to the other courtroom, and he can call his next witness after we complete with Ms. Patterson and giving the state an opportunity from the neighboring courtroom. And once you can promise to this court that you will abide by the rules of decorum and civility, and if you're willing to conduct yourself consistently within that, then I will allow you to come back over.
So why am I being held in contempt now?
I'm
There he
not
goes
holding you
again.
in contempt.
Then what did I do?
All right, I'm going to step off.
You're breathing.
interrupted
That's what you
repeat.
did. Nobody.
Will I at least be told why I'm held in contempt when I didn't do that?
Yeah.
Civil or criminal?
That's a misstatement of what I did, sir.
I wish you just wouldn't answer him at all
So why am
anymore.
I will advise when the jury's coming in, and if you can't be quiet, you're going to be muted, sir.
You're gonna mute me anyway.
Yeah, you're right. Mute him. Mute
Not if you're
him.
quiet.
He ain't gonna be quiet.
So I gotta be quiet like a little kid?
It's not
You
what I
are a
said,
kid.
sir. You have to be respectful. You have to be respectful of the proceedings.
But nobody has to be respectful to me though.
Yeah.
That's a mischaracterization as well.
No, you don't deserve it.
So can I say for the record that two of your bailiffs was just making gestures behind my head and I seen them through the TV screen and made me feel uncomfortable?
Oh.
Jury's coming in. Please rise for the
He
jury.
feels bullied and picked on and
So that's not
threatened.
gonna be addressed.
Mr. Brooks, I'm muting you.
Nah, it's not about you.
Oh, okay.
He is so self-centered. He thinks everything is about him.
Preliminary instructions for a second. Oh, sure. Should just keep them. They're nearby. Thank you, everyone. Please be seated.
Look at him peering in there. I wonder if they can see his giant face on the screen. Excuse me.
Just for the record, Mr. Brooks is appearing from another courtroom. That should not affect your deliberation or verdicts in any way. At this time, does the state have any questions for this witness?
I don't have any questions for Ms. Patterson.
All right. Thank you, ma'am. You may step down. Thank you for being here.
Bye-bye, Erika. Take a long look. That's your last time of looking at her.
All right. The defense may call its next witness, please.
Look at him. If you can't hear her like you were complaining about, put on your headset.
Go ahead, sir. You can call your next witness.
I thought I was muted.
You're not muted.
Oh my God.
So how long am I supposed to stay in here now?
I'm going to excuse the jury. We'll hopefully have you back shortly.
See, and the jury gets to
All right, for the
see
jury, please.
him, probably on the monitor, and hear him acting the fool. You know they have to be so over him by now. No more Erika for you.
All right, the jury is no longer in the courtroom. Mr. Brooks, I had the jury leave the courtroom because it appeared to me you wanted to perhaps either ask to come back into the courtroom or make another record of something. Do you want to come back into this courtroom as you call your next witness? You're not
Quit
muted.
I wish
You're
I
unmuted.
can't stand when he says that. He knows he's not. Am I muted? Am I muted?
So what's going on now? Why am I being held in contempt yet again?
The record will reflect that pursuant to Illinois versus Allen, Mr. Brooks was not held in contempt, although that is one of the possible ways for a trial judge to handle a defendant who is stubbornly defiant, disruptive, and contemptuous. That is not the only way in which a judge can address a defendant that is being discourteous, disrespectful, and disruptive. So pursuant to the authority in Illinois versus Allen, I found that you forfeited your right to be present based upon your conduct. I'd also direct the parties to some persuasive authority from other jurisdictions that are more recent, including People versus Cone from the state of Colorado, 160 P. 3rd 366. It's a Colorado Court of Appeals from 2007. And then from the state of Washington, from their Supreme Court, State versus Davis, 461 P. 3rd 1204. That's from 2020. And then I'd remind the parties of the district court decision that was later affirmed from Pennsylvania, U.S. versus Jennings, 855 F. Sup. 1427 from 1994. The finding was, sir, that you forfeited your right to be present based upon your conduct.
Okay, and all those case laws you just cited are pursuant to that.
Sir, I will ask you, would you like to come back into this courtroom as you continue with the calling of witnesses and your next witness?
I thought you was using Illinois versus Allen.
You are welcome to come back into this courtroom, sir.
So why was I removed in the first place then?
Just
I've
stop
made my
it.
findings. The record will stand. I will ask you one last time. Would you like to come back into this courtroom as you call your next witness?
You're not finna hold me in contempt no more. Not finna do that.
Mr. Brooks is not answering my question directly, so based upon that, I'll advise him that if I will ask one more time and he
You
fails
see?
to answer it with a yes or no,
See, the thing is, that last time was supposed to be the one more time, and then she adds another one more time. That's what frustrates me about this judge.
I will take that as a no that he wants to stay in that courtroom.
You can't answer
Mr.
for
Brooks?
You can't do that. You can't do that.
Mr. Brooks, I'm advising you that I will.
Get a lawyer. You don't
He's
know the law.
interrupting me once again. From
Okay,
the
you
other
talk.
courtroom.
You the one talking right now, so don't do that.
I'm going to mute him because he's not being respectful and he's just spouting off. You are unmuted, sir. The jury is on its way in. Well, will be shortly.
Why didn't we address subject matter jurisdiction when I was over here?
I'm going to mute you if you do that, sir.
I'm not gonna do it when the jury. That's why I asked now before the jury came in.
I
You
addressed
stop
that
it.
in my opening type remarks and record when we came back on the record today. I already addressed that.
So will it be proven for the record?
So he did not answer my question directly. He has not reclaimed his right to come back into the courtroom because number one, he has not requested it. Number two, he hasn't answered my question about whether he wants to come back in. And number three, he hasn't stated or demonstrated a willingness to conduct himself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. I will give him one more opportunity.
Oh, don't. Just say you're done. You're
So that
staying
it's
in there.
abundantly clear on this record that I am honoring his right to be present and I will unmute him. Sir, would you like to come back into this courtroom as you call your next witness?
Don't try to seem like you're trying to honor my rights now because you haven't.
Okay,
been doing
he
it before.
is, again, not answering the question
Don't try to
directly.
put on no. Don't.
I'm going to mute him again. As
Oh,
I've
thank
noted
God,
before, this is a
please.
clear method now that Mr. Brooks is employing, that when I have done something that he disagrees with, that he just continues to argue with me and does not answer questions directly. So based upon his continued disruptive behavior, the fact that he will not answer my questions directly, I'll find that he's continuing to forfeit his right to be present in this courtroom. Clearly, the audio and visual technology are working. He's been responding, although not appropriately. He is in that other courtroom. We can see him. He does have the headphones on, and I've confirmed that he can see and hear as well based upon the court personnel that are in the other courtroom. So I'll make another finding that his appearance from the other courtroom is the functional equivalent of him being present in this courtroom. Mr. Brooks, before I unmute you, I am going to advise you, I will ask you to call your next witness. And if I don't get a direct response out of you, I may ask it again. And if you fail to give me a direct response, then you will forfeit your right to call any other witnesses.
Please do
So
that.
I'm going to unmute you. Actually, I need to bring the jury back out. But before I do that, I will unmute you first and ask you which witness you intend to call, so we can at least have that person ready to go and outside the courtroom. Who will be your next witness?
I'm not calling no witness if I gotta be in this other courtroom.
Would you like to come back into this courtroom, sir?
No, don't
Why
let
was
him.
I ever removed? You
Oh
never
my
answered.
God.
I've
I
made
gotta
a
answer
record of that,
everything.
sir.
I have to answer everything though. Everything you ask me, you expect me to answer. But then when I ask you questions,
that's
you never
right.
have to answer anything. I just put on the record that 2 of your bailiffs just made gestures when I'm looking at them.
I know, we heard already.
Screen, they're making gestures behind my head that make me feel uncomfortable. I just brought that up on the record. You didn't even address that.
Mr. Brooks, I didn't address it because frankly you keep interrupting me and then I have to deal with the interruptions and make a record regarding that. So I just saw the captain walk over. I will let security personnel, Captain Dussault, look into that, and if appropriate, he can bring that conduct to my attention. I'd also remind the defendant that at any time you can also ask to be brought over through the bailiffs who are in that courtroom. So to be abundantly fair to you, I will ask one more time, would you like to come back over to this courtroom?
I should have never been removed.
Yes,
That's not answering my question,
Okay,
sir.
see, right there, when he answered like that, she should have said, okay, leave him. I'm telling you, that's how we deal with the kids. You know, even those who have challenges, because they even know how to push your button. And it's like they're just going to keep doing it and trying to see how far they can get, and which he has done and been very successful, instead of her just saying, okay, because he's trying to tell her what he's going to do, or what he's not going to do. And I can't stand it. This is what gets me aggravated about her. Like I said, I like a lot of things about her. How she handled these things, no, not so much.
You haven't answered my question.
The court's not going to answer questions directed at the court by the defendant because they're not relevant or probative at this time, and they're a delay and disruptive tactic.
They're
Mr.
not
Brooks.
a delay and disruptive tactic.
Yes, they are.
A judicial determination that you're making.
I'm going to mute you because we're going
Please
off on the judicial
mute him.
determinations. Every decision I make, sir, is by definition a judicial determination. It is on the record. If there is a conviction, you can raise whatever issues you want on appeal if you are convicted. But we don't need to have this back and forth every time to further make the record when the record speaks for itself. You were given plenty of opportunities throughout this trial to make offers of proof, to state your legal reasoning for either an objection or for a question that's being asked or for a whole host of other things. But right now you're not doing anything legally relevant, you're being disruptive. I would like you to be present. That is always what I want during this case. It certainly, I think, is important, but you can forfeit your right to be present by your conduct, which you have done repeatedly throughout this case. I will advise you that if you are in that courtroom, because I have put you there and you have not reclaimed the right to be present by number one, asking and then expressing a willingness to conduct yourself consistently with decorum and respect inherent in the concepts of courts and judicial proceedings, you will remain over there. and it looks like he took his headphones off. So I will. Mr. Brooks, I'm advising you that if you fail to call a witness, you will forfeit your right to present any additional witnesses. And I'm doing this outside the presence of the jury right now for a reason. I need to know from you right now, you are unmuted. Who is your next witness?
Oh my gosh, trying to say something to me. Yeah, too much talking going on.
What you trying to say?
That was very disrespectful, sir. You chose to take off your headphones?
Yeah,
You choose
because
to
I'm
read?
muted. I'm muted. So
Ugh.
why am I gonna have my headphones on and I'm muted?
Well, I would think your headphones help you hear. The
They
muting
do.
is so that I don't have to hear the disruptions.
Okay, well then why should I need to hear what
So
you
let
say?
me be clear, sir. And
You
you
don't
are
gotta
not.
be clear or nothing. I don't gotta listen to you.
Don't say anything.
I will ask you one last time,
No,
sir.
don't. Don't
Who is
ask
your
him.
next witness?
Don't ask him anymore. I can't stand when she does this.
Is she talking to me again?
This.
We gotta keep doing this little childish stuff, dude.
Yeah, you're the child.
I gotta sit up here and I'm supposed to abide by every single rule, but don't nobody else gotta do that.
Oh, man.
The record should
Judicial misconduct.
reflect that Mr. Brooks is spouting off, making
I think
unsubstantiated
the record can hear me. I
allegations
think they can hear me.
against this court,
Unless I'm
directly
muted.
attacking the integrity of this court and these proceedings, while yet
This court ain't got no
refusing
integrity.
to answer
This court don't have
simple
no
questions. Mr. Brooks, you
That's
are,
not my name. I told you I don't consent to being called that name.
sir, you are hereby advised this is the last time I will ask this question.
Is she,
Don't talk
Or
oh
you will-
my gosh, is she really? I mean, I know that she does. I keep forgetting this stuff, though. But it's like, she's asked him, so she should have said, fine, you don't have the right to question any more witnesses, or at least that one. It's too many times. He doesn't deserve it.
Forfeit your right to present
Can't do that.
any
Show me what-
additional
show me
witnesses
where that's law.
because
Show
you
me
are
where
not
that's law.
cooperating with this process.
Show me that is law. That's all I'm asking. Show me that is lawful law.
Mr. Brooks,
How can I forfeit not being able to have a defense? Are you
Is that-
kidding me?
No, because you're acting like an idiot.
all I'm asking is that you conduct yourself with dignity, with decorum, and with respect. I will
Which she
gladly bring you
possesses
back
none.
into this courtroom so you can present your additional witnesses.
You're
But
right.
you need to ask me to come back into this courtroom.
With all due respect, I'm tired of having this back and forth with you every day. It's not my intention to come in here and have these interactions with you every day. It's not. Regardless
Lie.
to what you may think,
It's a lie.
regardless to how you may feel, that is not my intention. Okay?
A lie.
I simply do what I do because I do not have the understanding.
Get a
So
lawyer.
if I don't understand something, I'm going to ask a question.
Get a lawyer.
I apologize if it makes you feel that I'm intentionally trying to delay the proceedings. If
You
I'm
are.
intentionally trying to be disruptive.
You are.
Because that's not the case.
It is.
And I feel very, 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 very disrespected every time the record is made, making it seem like that's what I'm attempting to do.
It is what you're attempting
So
to
of
do.
course it's gonna frustrate me. Of course it's gonna make me a little bit upset.
Mm.
And I just want you to understand that. It seems to me the way I'm interpreting what you're doing, which is it is your courtroom. That's not it. It's not a dispute. It's not up for
Yeah, I
debate.
think it is. You think it's your
You
courtroom.
control what's going on in there. It's not a
No,
dispute.
you do. You try to.
But the way I'm interpreting what you're doing is that I'm being held in contempt. That's
Nope.
how I'm interpreting.
No.
Because one of the three things that's cited in Illinois versus Allen, one of them is being gagged. I haven't been gagged.
I wish you had been.
One of them is held in contempt. If
What's
I'm-
the
if
third,
I'm not
Mr.
under-
Brooks? What's the third?
The third is removed from the courtroom while the trial continues, right? That's the third, right?
And that's what's been done.
Okay. So now,
So now,
where does it say after
where
that
does it say after that
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 having me on
having me on
a headset
a
or
headset
being able to see
or
and hear and
being
all
able
this
to
and this,
see and
how
hear
is
and all
that
this and this,
not
how is that
prejudicing
not
my
prejudicing
defense?
Sir, you can
I
raise
can't
that
even-
issue on
I can't-
appeal.
can't even-
You
I-
can
this is
raise
why I
that
say that.
issue on
This is
appeal
why I
if
say
you
that.
are
This is why I say
convicted.
that.
This is
This
why
is why I
that.
say that though,
This is
because
why
I
I say
can't
that,
even
though.
see.
Because
The
I
only
can't
thing
even
I can see right now when I'm looking at the
see
TV
right now when I'm looking
is
at
you
the TV is you
and the prosecution table. I
and the
can't see
prosecution
anything
table.
else.
I can't see anything
Oh,
else.
you poor
I understand
thing.
that, sir. I'm fully aware of that.
So I'm not fully
So
aware of
I'm
what's going
not
on in
fully
the
aware
courtroom.
of what's going on in the courtroom.
Oh, you're aware enough.
Don't I deserve that right
Don't
to
I
be able to
deserve
see
that
and
right
hear
Yeah,
to be able
everything
not
that's
really.
going on?
hear everything that's going on?
Nope.
If you can conduct yourself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings, the answer then is yes. So, I'm not going to have a debate with you about the law. I will ask you again, would you like to come back into this courtroom?
Are you going to kick me out?
Are you going to kick me out?
See,
Sir,
close
I'm
it
asking
down.
the questions right now.
Close it down, Judge.
Would you
Close
like to
it
come back
down.
into this courtroom? Yes or no?
Are you going to kick me out?
Yeah, just keep him
Sir,
out.
it's a yes or
Close
no
it down,
question. Would
Judge.
you like to come
Well,
back
my
into this?
answer,
Close it
my
down.
answer was based on the reason why I'm answering like that is because the moment I say something, it's going to get me put out. I don't want to keep
Well, then
falling
shut
into
up.
back and forth and back and forth and back and forth and back and forth.
Mm.
It makes essentially it wastes his time, really.
It wastes his, yeah, it does waste his time. And she's
I'm
letting him
well
talk
aware of
way
that,
too
sir.
much.
That it delays the
Yeah, but-
proceedings.
She's letting him talk way too much.
But then it's laid at my
Shut
feet
it
as if
down,
that's my
Judge.
attempt. You think I want to be over here?
Sir, I don't know what you want or don't want at this time. I know that we need to complete this trial and that you have frustrated today more than ever before the ability of this court to do that.
Well, I apologize for you feeling that way, but I'm
Yeah,
frustrated.
see, that's not an apology.
Nobody seems to take that into account. I'm just as frustrated as everybody.
Nobody cares.
Probably
How,
more.
nobody
Then I
cares.
suggest that you conform your conduct to the requirements
There
of
is no
courtesy and
conduct,
decorum
Your
so
Honor.
that you don't run the risk of forfeiting your right to be present. But
But
that
there
falls
is no-
on you and you alone, sir.
See, right now, if y'all agree, let me know. She's talking too much. It's not going to change. Just it's the same as a child. It won't change unless you call their bluff. Just make him stay there. Shut him down.
There is no conduct. I don't understand what you mean by
I
that.
don't understand.
I really don't.
Mr. Brooks,
It's a raving
you may
lunatic.
not understand it. I don't think that's accurate. I think you know exactly what you're doing.
I agree with that.
If that's what you think, that's fine. I
And
can't argue with
you have
about yours.
demonstrated throughout this case that you pay attention to witnesses' testimony, that you make cogent and coherent objections. At times that you have even had evidence suppressed in this case or stricken. That's the word I used during this case. You made an opening statement. You communicate with witnesses.
Yeah, he berates them.
So
Your
you
Honor,
clearly
it's
read,
not
write,
fair.
and understand English. That's not an issue
not-
here, sir.
It's not fair
Are
to
you
say-
self-represented?
It's not fair.
Absolutely. Does that present difficulties and disadvantages? Absolutely. But that takes me back to when you waived your right to counsel. And you did so knowingly, freely, voluntarily, and with
He
a
almost
full
lost the top of his
understanding of the
box.
disadvantages and advantages of doing so, meaning advantages of having an attorney, the disadvantages of doing it on your own, and you made a deliberate decision to
Your Honor, that's
represent
not fair.
yourself, and that comes at a risk to you of, yes, at times not fully understanding the law, the rules of evidence, the rules of procedure, but you
That's
do
not
so
fair.
at your peril.
That's not fair to state, Your Honor, because
It is fair.
So I'm going to do the following, since I'm not really getting anywhere. I'm going to mute you for the moment. I'm not getting anywhere with him. I would like him to be brought over, and he has a choice to make. He can come back over or he doesn't. Either way, he's going to be asked to call a witness in front of the jury. I will ask him 3 times if he fails to give me a direct answer, and after the 3rd time, I will make the appropriate finding, but I will do that outside the presence of the jury. But we are going to continue. So we'll go off the record and he will come back over here. Thank you. We are in recess until that happens.
Okay, so the judge just, of course, everyone just walked out of the courtroom momentarily, and I was getting ready to kind of move forward to where they were back in the courtroom, but I noticed that I can hear the mic on in the courtroom where Brooks is, and he's blathering on. It seems like you can hear it. I've got everything up as loud as I can, so let's give it a try.
Don't y'all get tired of hauling all this stuff over here? And I know, as soon as I say something, she gonna say, take them out, we're gonna stop everything, take them out. It's just like, well, damn, I could have stayed over there. Like, what the? Yeah, at this point, it's like, what the hell? I'm gonna go over there and get sent right back over here. And then when I get over here, it's gonna be the same thing. Oh, well, if you tell them you can come back over here, then I go back over there, then I get kicked out again. Then it's the same thing again. Oh, well, if you want to tell, it's just like, dude, pick, man. Like, obviously, I don't have no say. That's clear. Because when I'm getting kicked out, the first thing I say is what? So why are you holding me in contempt? So that's obviously saying, why am I being kicked out? So if I'm saying, why am I being kicked out, then obviously I don't want to be kicked out. But then I'm kicked out anyway, and then I get over here, and it's just like, okay, I don't want to be over here, but why did I go back over there?
They must have discovered it was on. But I don't know if y'all are able to hear that. I guess I'll find out when I play this back. But it's the same stuff, though. It's like he acts like he doesn't take responsibility for anything. It's like, they're gonna just send me back. Well, you know what? You know how to remedy that? Shut the hell up. Don't talk. Don't be disrespectful. Don't act like you're the only person in the courtroom. But he doesn't know how to do that because he believes he is the only one. He believes he's the smartest one. He believes he's the only one that's right and everyone's wrong. And then he'll say, I ask, why am I in contempt? Why am I being held in contempt? Already knowing that that is not what is happening. I really personally think the gagging part would be having him gagged would be the best. But again, no one asked me. So we will get back to when everybody's in there.
In the courtroom in person and in custody wearing a suit and tie. Actually, his suit coat is off, but he's still wearing a mask. And the jury will be brought out and you'll be asked to call your next witness.
You called that name.
So noted.
And we still need to address subject matter jurisdiction before the jury's brought out.
I will not be doing that.
Will it be proven for the record?
The record stands.
So is that a tacit agreement that you don't have to answer that question, Your Honor?
He still won't shut up, will
I
he?
make no such agreements with you, sir.
So that means you can answer a question then. Will we be addressing subject matter jurisdiction on the record, and will it be verified and proven? Non-responsive answer is a tacit agreement, Your Honor.
Jury's coming out.
Sorry, guys. He looks like a beaten little boy. It's going to be hell to pay because Erika is gone. He can't control her anymore. He didn't get his way.
Thank you, everyone. Please be seated.
So he's going to behave pretty badly, I assume.
The defense may call its next witness.
Who's here?
Who's here? Okay, are you kidding me? Are they going to have to call out the list of people? He can't do anything. He can. He just chooses not to. Look how slouched he is. No more Erika. Yep, he's gonna behave pretty badly probably from here on out.
Bertram, Hayes, Aldrich, and Lescano are present and ready, Your Honor.
Thank you.
What was the last two?
Aldrich and Lescano.
I know, here I go again. But don't you think that looks pretty bad for the jury? For him to act like that, who's on the list, and act so ill-prepared and just, lazy and disgusting and vile, and just like, how does he think the jury, and he's so worried about the jury needing to know about all of his made-up stuff, and he's acting like this? It's incredulous. It's mind-boggling. Eeny, meeny, miny, moe.
Let's go with Deanna Aldridge.
Deanna Aldridge? All right, very well.
Yeah, put that Bible up there. That's not going to do you any good. Okay, I am stopping this for this session because it's like, I don't know, at least probably 3.5 hours. I mean, it's mostly, as you already see, I believe chocked with a lot of good stuff. And I assume as he starts calling these next witnesses, there's going to be some more drama. But I figure this is a gutful. I know just doing this, there was just a lot of things. I don't know why it took, it was very long, but there was parts that I thought I got, but I didn't, and it took me very long, and I have just gotten a gut full of him, and so I'll be glad to get this one up. Hopefully y'all will enjoy it, and then I will be working on the next one. So, with all of that, thank you all so much for watching, commenting, subscribing. I truly appreciate it. I truly do appreciate you all as we go through this crazy ride. But remember, be kind to one another. Be kind to you. Remember, I love you all. And I will see you the next time.